And we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, and good morning, and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel. My name is Ariane Vuono. I'm joined today by Justice William Mead and Justice Shin. Just two quick reminders before we start. You each, of course, know, I've seen you, both of you argue many times before, that you each have 15 minutes to present your argument, and there is no rebuttal. And second, upon occasion, we've had some technical difficulties with the remote platform. Usually, any problems get resolved very quickly, so just please be patient. And also be assured that you will not lose any of your time for oral argument if that should happen, all right? With that said, I'm going to call the first case, Commonwealth versus Dominic Ballard, 2020-0298. And we'll start with you, Attorney Chekatoff.
Thank you, Your Honor. If it please the court, Robert Chekatoff for the defendant, Dominic Ballard. This is a case, as I know you've read the briefs, of two college students who thought that Tinder was a good idea. And it's basically a he said, she said case. And I've raised two issues, both of which I want to address at least a little today. And they're both, they're not revolutionary ideas. They're standard issues that often arise in these cases. The question is, were they handled correctly in the appeals court? I'm sorry, in the trial court. Yeah. Mm-hmm. So the first is the issue of consciousness of guilt. Mm-hmm. My sister says in her brief that I don't quarrel with the instruction that was given in terms of its accuracy as a consciousness of guilt instruction. That's correct. My quarrel is whether or not it should have been given in the first place. Now, it strikes me when I read this record that there was something that the trial court could have done on the consciousness of guilt in the consciousness of guilt area, which was these apology texts. It seems to me one could legitimately argue the apology texts themselves are consciousness of guilt. In some ways, they're classic consciousness of guilt evidence, but that's not what the trial court focused on. The trial court.
If I may ask you a question. If the jury were to believe, and that's what the judge said to them, if they were to believe that your client had indeed deleted certain texts that could have been considered to be inculpatory, wouldn't that constitute consciousness of guilt evidence?
No, my argument is the sending of the text might be consciousness of guilt, but the deleting of the text could not serve as a basis for a consciousness of guilt instruction. And it's a very powerful instruction. It basically tells the jury, if you find this, you should not convict based on this alone. That's a very powerful instruction. And the reason is, smartphones are a very interesting phenomenon in our society. And consciousness of guilt is like any other inference that we have. It has to be possible and reasonable. And we have to have some baseline from which we make this inference. And how you manage your smartphone seems to me to be not a rational basis for deciding.
Wasn't the evidence not necessarily how your client was managing his smartphone in general, but that at the time that he was giving an interview to the detective in Amherst, that, or maybe they were in Belgium, I think they were in Amherst PD, that at that time she observed him manipulating his phone.
Yeah.
That was her testimony, was it not?
That was the police officer's testimony. It's on video. But the trial judge said that would be total speculation. to come to the conclusion that he deleted it at that time. So it does become his general practice with the cell phone. So the trial judge rejected that as an evidentiary basis.
I thought, Mr. Sheketov, I thought the judge said that you may have evidence, inculpatory evidence by the deleting of the text.
That's what he said.
And if you so find, then he gave the rest of the instruction.
Correct. But he specifically says on the record, Your Honor, that the idea that he deleted it during the interview is pure speculation and could not serve as the basis.
Okay.
Well, why is the timing important? If he deleted them then or at some other time?
So
he deleted them.
Yes, he deleted them. So is the way he handles his smartphone a grounds for deciding that? Well, what if he deletes every text that he gets? What if he deletes?
That's, I mean, he could have testified to that.
Right, but he wasn't cross-examined on that either. And the real issue is not whether or not there are explanations for this, because then you get if there are two possible inferences, one of innocence and one of guilt, you get a consciousness of guilt instruction. It seems to me that in order to get a consciousness of guilt instruction on the way you handle your smartphone, you are making rules about what people must do with their smartphones in order to avoid a consciousness of guilt instruction. Must I keep on my smartphone every text that I've ever sent out, every text that I've ever received, every email that I have? It seems to me the Commonwealth could have created a record where this particular deletion stands out because they had everything on a smartphone, stands out in a way that other deletions.
I mean, it seems to me, Mr. Sheketov, that's something that's ripe for argument. And what if this was a bank robbery, okay? And the defendant successfully removes the money from the bank, and at some point he realized a dye pack has gone off in the bank satchel, and so he looks and he realizes that this money it can't be used, and he's seen on video disposing of the money in a dumpster nearby the bank. Is that consciousness of guilt?
Yeah, that's consciousness of guilt. So, for instance, Your Honor, flight is also consciousness of guilt. If I had won a trip to go to Europe for 2 weeks, and the night before I'm in some sort of criminal activity, and then the next day I fly off to Europe on the trip that I've won, that I've had tickets for months, and I return at the end of the 2-week trip that I won, that is quote unquote flight, but no one would take the position that that could serve as a consciousness of guilt.
Well, I think that's something that can be explained, and the judge didn't say that it was that the texts were inculpatory or there was consciousness of guilt. He said he left out the possibility. So in my hypothetical, the defendant or his attorney can argue he was just being a good citizen. He saw this dirty bag on the street and he was throwing it away.
I agree, but it seems to me that in order to draw any reasonable inference from what one does with one's cell phone, you have to know what one does with one's cell phone generally, because otherwise you're imposing a requirement on people on how to manage their cell phones. If in fact he had no text messages of any kind on his cell phone, could that serve as a basis of consciousness of guilt, that he had also deleted these two?
I don't think the hypotheticals are necessarily helpful when we actually have the evidence in this case that that particular text was not on his cell phone. So he had access to his cell phone. He had, as Judge Smith is pointing out, he actually took the stand and testified in this case and had the opportunity to explain his own habits or his own way in terms of how he manages his phone if he had wished to do so. You didn't argue, if I understand it, that he was surprised by the conscious of guilt evidence instruction, so therefore he would have testified differently. That's not an argument that you've made, correct?
So no, the decision on whether to instruct on consciousness of guilt was made after he testified, not before. And in fact,
Right, but there was no question about reopening the evidence or about his being able to give some other testimony about his cell phone, correct?
That's correct, Your Honor.
Okay.
My position is that you cannot have a reasonable inference of consciousness of guilt from the fact that somebody doesn't keep all their messages on their cell phone without some more specific background. So I'd like to move to my second issue,
Okay.
which is this question of completeness. So I say, and my sister points out that this is my single best reference, actions speak louder than words. And this is an idiom that goes back centuries. And so I'd like to give an example in this case, which is not this case. Let's say the defendant said in his statement to the police that she took off her clothes. She then took off my clothes. She began rubbing me. She began kissing me. And then she got on top of me and she inserted me into her. All the time saying, not today, not today, and giggling about it. Could the Commonwealth then say that the only thing we're bringing in is her saying, not today, not today? Because those are the only words that came out of her mouth. And the rest of it is on another topic. It's something else. And my answer to that is obviously no, because those actions speak. They're the same as words. It's on the exact same topic. And without those actions, you have no way of evaluating the words that come out of her mouth. Now, the circumstances in this case are not as extreme as the example that I just gave, but they're significant, including that she took his pants off. This is in his statement, and that they were kissing the entire time, and that he did not have to force her legs apart.
But I view the topic of what was admitted to be whether she consented to the act of sex. And I think the difference with your hypothetical is that what was excluded were his statements about what happened leading up to that statement. So, I mean, even if she did take off his pants and was kissing him before she said not today, how is that necessary to explain her later statement that she didn't want to have sex? Because it seems like the judge did admit the portions of this statement that described the events that were more or less contemporaneous with the statement that was admitted.
Right. So respectfully, Your Honor, I would take the position that the stuff that happened immediately before matters. But in this case, I don't have to take that position, because what he said to the police was that they were kissing throughout the entire sexual activity. In other words, while the quote unquote rape was going on.
But that came in.
No, it didn't.
Right. No, there was a portion of what was admitted that where he said to the police that she was giggling and they were kissing pretty much contemporaneously with when she said not today. So that portion was admitted.
I respectfully disagree, Your Honor. The giggling came in, that they were kissing earlier came in, but that they were kissing during the actual quote unquote rape did not come in. And of course, the judge explains to the jury, don't speculate about what's left out. And when you tell your story later on the witness stand, and you add this stuff in, it looks like you're making it up.
So,
Because
Counsel, I'm looking at your brief on page 17, where you quote what was admitted, and part of it was the defendant saying, at this point, she was still kissing me and stuff, and I thought she was just like teasing or whatever.
Yeah. So I think if you look at the entire statement, the fact that she was kissing him during the sexual act is taken out. And this is the part that precedes it. If you read the part that's omitted, he says that they continue to kiss all through the sexual act. And I agree with your analysis that the topic is whether or not she consented. And the things that they physically did together speak volumes. So I'm out of time.
Thank you.
Okay. Thank you very much. Attorney Stott?
May it please the court. Thank you, Your Honor. I want to begin with the issue about defendant's motion in limine to admit the entirety of his recorded statement to the Amherst Police Department. That was the motion that was denied, and that's the issue before the court. And I'll begin with the argument of counsel. Defendant at trial and in his recorded statement certainly put forth the broader narrative that actions speak louder than words, and that no didn't mean no. But defendant's statements about conduct, the ones that were excluded by the trial court in terms of the Commonwealth's case in chief, are not on the same subject. And here I'm going into the law on the same subject. If you talk about the case Eugene cited in both briefs, I believe, it's not on the same subject, and it's not necessary to understand the excerpts that were admitted. That's two of the three prongs in Eugene: same subject, same conversation, and necessary to understand the argument. And as the court has noted, the excerpts themselves provide details that give context that would support defendant's narrative. She was teasing me. She was kissing me. I thought she was giggling.
I just brought that up actually on my screen to double check, and with respect to what was introduced at trial on page 202, and there is that quote there about she was still kissing me and stuff. I believe that's the same quote that Justice Shin was referring to earlier.
Yes, those are on page 36 and 37 of the transcript, and on page 201 to 204 of volume 2 of the trial transcript. That is a transcript of a recording played during a trial, so it doesn't necessarily reflect actually every word that you see in the transcript, and it doesn't distinguish between the different excerpts. In other words, when Exhibit 9 was played at trial, the excerpts were divided by spaces, sound spaces.
I see.
And so the jury could hear those gaps in between. And the judge did instruct on not to speculate. Mm-hmm. So I want to focus on defendant's main argument, actions speak louder than words. Even that phrase itself delineates, as the trial court did, between two different subjects, actions and words. And if you follow the case law after Watson, I noticed Eugene with the three prongs, but there is specific delineation that is permitted within the trial court's discretion in terms of admitting some excerpts and excluding others. And the first thing to think about in terms of this entirety of the statement outside of the excerpts that were admitted in trial Exhibit 9 are that these are all hearsay statements that the defendant wanted to admit, his own exculpatory statements. And if you look at the case cited by the defendant, it's a federal case, but it's talking about a parallel issue, Boylan. It discusses the doctrine of completeness in terms of the entirety of what a person said on a specific subject, on a given subject. And it makes clear that this doctrine neither mandates nor delineates a particular strata. In other words, if you introduce statements about speech, defendant's admission about what the victim said, you don't need to admit statements about the defendant's statements about what she did.
Well, how do you respond to your brother's hypothetical that he, the one he started his argument out with, about actions that are occurring contemporaneously with her saying at the same time, no? That portion wouldn't be admissible?
I think in each case, a judge has to make a delineation based on the facts of that case. And in its discretion, the trial court makes that delineation. And the language in the case Boyland and in Morera, which is about statements against penal interest, the precise dividing lines between the two topics or subjects is within the discretion of the trial court. And in that case, perhaps the delineation would be different depending on the entirety of the evidence in that case and the entirety of the statement. But what's important here is that the excerpts offered to the jury with the permission of the trial court didn't confuse what the defendant said. In other words, it's not as if the defendant said, she said not today, but I didn't hear that because there was an airplane going overhead and I didn't hear her words. That would be necessary.
What if her words are contradicted by the conduct that's occurring while she says them?
And that goes to the defendant's narrative in his statement and his trial testimony. He put that forward as his theory of the case. And that was fully admitted both within these excerpts, giggling, teasing, kissing, and in his testimony. And the fact that his testimony, trial testimony, was inconsistent with his excerpts, and he admitted that his trial testimony was inconsistent on these topics, caused him prejudice. It was not prejudice to him that the trial court delineated between those two topics. And in a different case with different facts, that delineation might be.
That's why I find it a little odd to delineate the topic as verbal versus non-verbal, as opposed to did she consent to the act of sex, right? Because the judge did admit his statements about her conduct that occurred more or less contemporaneously with her saying not today. He just excluded what came before. So, you know, going back to your brother's hypothetical and Justice Mead's question, if he told the officers she inserted me into herself while at the same time saying not today, would that earlier portion not be admissible to qualify the latter statement?
In that particular case, if those were the facts, the judge may read the transcript of the statement and delineate it that the statements went in. I think the case, I don't think either party cited it, but Creighton, which is 470 Mass 228, is a case where the trial court delineated the defendant's excerpts to come in because it was necessary to understand the excerpts that the Commonwealth had offered. But in
do I hear your response as being an affirmative response to Justice Shin's question? Is the answer yes?
I'm saying that it would be left to the discretion of the trial court to make that delineation in that fact situation. And it may be that it would be necessary.
Okay.
But in this case, the defendant's statements about the victim's conduct that were excluded in terms of the Commonwealth's case in chief, they were not either on the same subject and they were not necessary to understand the admission by the defendant that the victim said, no, not today. Did that answer the question? So The statement in Morera is particularly on point in terms of this precise issue, and the court uses that word, precise dividing lines that we endorse here, splitting the evidentiary qualification and admissibility of particular self-incriminatory statements and any necessary surrounding context that are directly against the declarant's penal interest from the not directly incriminatory and broader narrative statement in which the penal declaration is embedded. And that is why I answered the question in another case with different facts, that precise delineation might be different. But in this case, there is no statement that the defendant made anywhere in that 1 hour recorded statement that is necessary to understand that he heard the victim say, no, not today. With respect to any prejudice, which if we assume that the trial court erred in making this precise delineation, and assuming that the defendant properly preserved this issue, and so that prejudice is the standard, as we discussed, the excerpts that were admitted in Trial Exhibit 9 contain defendant statements that he thought she was teasing him, she was giggling, she was kissing him. Second, defendant testified at trial. And as I indicated, his trial testimony differed in key respects from what he said in the recording, and he acknowledged these discrepancies to the jury. He put forth the narrative that actions speak louder than words, and he put the narrative forth on the basis of inconsistent statements about what had happened, and the jury didn't credit that testimony. And he may have been prejudiced by that inconsistency and by putting forth this narrative to the jury, but that's of his own making and not the trial court's ruling on the motion to eliminate. Further, there was substantial evidence of guilt on count 2, on which he was convicted of rape, not the least of which was Exhibits 1 and 2 of the 2 texts that are inculpatory sent to the victim by the defendant from his phone within hours of the sexual intercourse, in which he admits, I know I forced it, and in which he says, I'm sorry, I effed up. And I leave out the obscenity. The jury also had the victim's testimony, which was corroborated by an extensive first complaint text. All of this evidence taken together shows that there was no prejudice from the delineation done by the trial court under Commonwealth versus Watson. Any error in this context could have had no effect. The jury had all of defendants' versions of the victim's conduct, and they convicted him on the rape count anyway. I'd like to use the 2 minutes I have left to address the consciousness of guilt instruction. Defendant counsel said that there's no specific background to support the consciousness of guilt instruction in this case. And I would just like to summarize the specific evidence that supported the trial court's instruction. There's no question that the defendant sent and wrote these 2 inculpatory texts within hours after the sexual intercourse. There's no question that they are inculpatory on their face. Defendant testified that he did not remember deleting either of these texts. That's at transcript 370. And Sergeant Wise testified about the download of his phone, defendant's phone, the phone to which he unquestionably had access and used to communicate. And in the data that was downloaded by Sergeant Wise, one of the texts, Exhibit 2, the one in which he says, I'm sorry, among other things, that shows up as having been deleted. The second text doesn't show up at all, and it doesn't show up on his phone, which would be Exhibit 1, I know I forced it. And Sergeant Wise testified that it could have been deleted. And finally, the argument made by counsel that somehow any text being deleted by somebody using a cell phone, whether it was by the person intentionally or by some algorithm in the cell phone itself, doesn't fly in this context with this evidence, because these are in fact inculpatory texts. They aren't just any texts to his mother or his family or whatever. These are inculpatory texts by the defendant to the victim hours after the sexual intercourse, and they were not on his phone. One was deleted for certain, one could have been deleted. And the instruction, which has the permissive language that the court has already noted, was fully supported by this evidence. Thank you.
Thank you. I'm just going to check with the panel, see if anyone has any additional questions to follow up. I see none. So I want to thank you both very much. The briefs were very well done. We appreciate that, of course.
And we are back live and on the record.
Thank you very much. All right, good morning and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel. My name is Ariane Vuono, and I'm joined today by Justice Sydney Hanlon and Justice Sukyoung Shin. I want to tell you just two brief reminders that you each have 15 minutes to make your argument, and there is no rebuttal in the Appeals Court. And second, upon occasion, we have some technical difficulties. If that happens during the course of your argument, please be patient. We generally resolve them fairly quickly, and I can assure you that you will not lose any of your time as a result, if that should happen. So next, now I'll call the case. Commonwealth versus BAIRON UBEDA. Am I pronouncing that correctly?
BAIRON.
UBEDA?
BAIRON UBEDA, that's correct.
Okay, thank you. Number is 2019-1783. And we'll begin by hearing from you, Attorney Nocum.
Good morning. May it please the court, Jalanpan Nocum on behalf of the appellant. This is an appeal of two cases that were tried and should have been unjoined. One involving a minor, one involving a female adult who had a 3-year relationship with the defendant. They were factually and legally distinct. The case involving the minor was a one-time meeting where identity was a live and significant issue. As the court may have noted from the record, the identity issue, in fact, led to a mistrial in the first trial. Mm-hmm. In that particular case, the indictments were sexual in nature and, in fact, led to the most heightened sentence that the defendant received. In the second case, indictments, a series of indictments, involved a long-term relationship he had with an adult female. It was dysfunctional. I think the record is pretty clear. The Commonwealth conducted an out-of-court identification inexplicably with the adult female. I suggest that was to cure any identification issues and defects involving the case where the minor was the complaining witness. With respect to the case involving the minor, additionally, the testimony and her allegations regarding what occurred were so significantly different than what was offered by the adult female that the cases really should have been separated. The prejudice that arose out of testimony from the minor cannot be understated. She was youthful.
Excuse me. You're going to say, I can tell you're already going to answer my question.
Her youth, her age, curried significant favor with the jury. It could not have. And it would have played into how the jury also assessed testimony offered by the adult female.
One thing, so identification is one of the specific reasons that other bad acts are admissible, right? On the issue of it's listed, motive, patterns, and identification is one of them. You said they're so different. How, apart from youth, which I understand, how are they different?
The identification involving the minor was that she did not have a clear opportunity to observe him. It was a one-time.
No, I'm sorry. The pattern of the offenses you said was so different. There should not have been joined.
Well, I would start with the Commonwealth's theory of the case, which was there was a pattern that the defendant, either through a real person or he pretended to be a female by the name of Crystal, reached out to both of the minor and the adult female on Facebook, asking them if they would be interested in participating what I think was an adult modeling project. Both of them responded, and that's what initiated the meetings between the two. With respect to that is my understanding in summation of the Commonwealth's theory of the case in what constituted the pattern, which they argued quite strenuously in closing, I might add, that this is the pattern of conduct that this defendant perpetuated to these women in order to engage them in the series of conduct.
And the evidence with respect to that was similar with respect to each of the alleged victims, correct?
What the minor victim, the adult female, and the purported witness who came in to testify to prior bad act.
So in all three cases, that was similar behavior, right? In all three of them, there was this reaching out for this modeling situation, etc. You would agree with that? Okay.
Someone who called themselves Crystal at the time.
That's correct. Yeah. My argument is this, is as unsavory as that conduct is, we still need to take the additional step of addressing whether it was unique enough to form the basis of evidence that could be a factor in, for purposes of identifying that this defendant, where it was the Commonwealth's, part of the Commonwealth's argument was that this pattern of conduct was coming in for identification purposes. So I think we have to ask ourselves whether or not somebody in today's age of social media and how people meet, whether somebody reaching out on Facebook in this particular instance and eliciting or soliciting somebody for a type of job and somebody responds, is that unique enough? That I suggest that it isn't, and the case law seems to suggest that some kind of distinct, unique feature is required.
Well, I think you've left out a critical detail, which is that in both cases, the person reaching out to Facebook identified themselves as someone named Crystal. That seems to me to be very unique.
I understand the uniqueness of having a specific name that was used to reach out to these to the women. My response to that is the act of reaching out, regardless of what the person, regardless of the name that the individual uses, for instance, is that in itself unique? I suggest in this particular instance that it is not. This court has addressed uniqueness, and I can give an example, although the name of the case escapes me, where the defendant hogtied a victim, which resulted in a homicide. And there was a prior instance in which he had done something similar. Well, the experts came in and testified as to the uniqueness in the way that the tide was conducted and performed. There are distinct and unique features in this particular instance that just not seem to be particularly so. In another instance, another case, I do not believe I cited it in my brief, involving a karate teacher who preyed on his students. The court there found that there were unique features in that he had a particular role with these students. He repeatedly encouraged them to overcome any of their shyness or barriers to their potential sexual explorations. So the court was able to identify a lot of distinct and unique features. And I go back again to where we are in how we interact with each other in today's modern world through social media. And that is, there's nothing unique about what this defendant did in the way that he
Let me just ask you one question, if I may interrupt you for just a second. So this is a ruling that the trial judge made that this particular pattern of conduct is unique enough so that it qualifies for not only for admission, but also for joinder of the cases, right?
That's correct.
So that would be, we would look at that under an abuse of discretion standard?
Yes, Your Honor.
So is there a case that you have that in which the this kind of conduct, that our court or the SJC has said that there's an abuse of discretion to join the cases in this kind of situation?
If I did cite to a case, Your Honor, I admit that it escapes me at the very moment.
That's okay. We'll read your briefs again, of course, but I'm just trying to see where you would draw the line as to, in other words, two cases you just cited to us involve arguably more unique circumstances than this one, arguably. All right. Let's say we agree with you on that. In particular, the case involving the hog tying of the victims. I recall that the knots in that case were very specific. And so there was more to what was going on. And I can't remember the name of that case either, by the way. So, but here, your argument is that this is not so unusual to begin going on Facebook and finding work. So I'm wondering where you draw the line.
Well, I know that there's no bright line rule. Certainly, that would have been nice to have found a case that said so, but that I can definitely say after an exhaustive research, I do not find such a case. I think in this particular instance, had there been more, I can't conjure up any particular facts that I could add to say, well, that's it, that makes it, that passes the threshold of making this distinct and separate enough that the court could say, without error, that the cases were properly joined. I just think that there's simply too much lacking in this particular case, or these two cases, that did not make it factually distinct enough to.
Let me ask you another question. Thank you for that answer. And that is, one of the considerations when we talk about joinder is judicial economy, right? And whether or not there's going to be a lot of repeat evidence presented. And it seems to me one of the main issues in this case was understanding where some of the events took place. 34 Holyoke, I can't remember exactly now the address, where it was, East Street, I believe, something. And when that had to come in two separate trials, I mean, all that information, so all the information with respect to how the defendant had access to that apartment, what his connection was to that apartment, et cetera, would have had to be introduced in both cases, even if there had been two separate trials, right?
Well, I think that there was no definitive evidence that the acts occurred in one apartment, although I understand that the police conducted quite a thorough investigation. I think that there was an insinuation that the minor victim was able to describe a blanket that the police either confiscated or took from the adult female's home. They conducted a DNA test and there was no match. I don't think that there was definitive evidence that there was a common place that the defendant used.
Although there was inference from which the jury could find that there was the same place, right?
Well, I think that the jury could.
You're in the same area, plus the blanket, plus him having her keys, or a key to her apartment and access to it certain times of the day. That jury could draw an inference from that, right?
I think so. I don't know. The question is whether or not that inference was reasonable. So if Your Honor is referring to the adult female and him having this relationship, it would not have been unusual for him to have the keys to her apartment, would not have been unusual for him to be there when she was not there. She did not know what was happening. The adult female certainly did not even suggest or insinuate that when she was not there, that something untoward was happening at her home.
But why does it have to be definitive evidence? I mean, the question is whether the evidence would be relevant and admissible. And it does seem like the jury could infer, based on, the photographs of the bedding and the officer's testimony, that the assault on the child took place at the adult victim's apartment. So, this is a ruling that the judge is making pre-trial. Why is it an abuse of discretion for the judge to determine that evidence would be admissible at both trials?
I think that I want to go back and maybe say something a little more overarching. That all the parties live in a very similar, in a close geographic location. One, there was confusion and uncertainty about where the locations were. The only person who was able to provide definitive testimony regarding location of conduct was the adult female. Everything else was pieced together. And I would suggest that the piecing together from the minor was not sufficient to substantiate that the conduct that the defendant used this adult female's apartment as a central location where he conducted these acts, which is, I understand, was part of the Commonwealth's theory of the case. So if the question is, if the cases were to be separated, and what follows then is, would evidence of one case be admissible in the other? I would say that certainly with respect to the minor's case, it would be very difficult for the Commonwealth to introduce that case, to introduce evidence of the adult female's, the facts of the adult female's case in her case, and vice versa. I think the case, they're just too factually distinct for them to be admissible. On top of that, assuming that they would be admissible, the court would still have to struggle with whether or not the evidence that its probative value is outweighed by prejudice. I suggest that in this particular instance, that would be a driving factor in the court's assessment as to whether, say, for instance, evidence involving the minor would be admissible in a case where the adult female is the complaining witness. The allegations are so inflammatory. The fact of the minor herself as a witness would be would elicit quite a fair amount of sympathy and empathy from a jury. So I think that there is that extra layer that the court would have to assess, and in this particular instance, there is just not enough for one set of facts and evidence in one case to be admissible in the other. I see that my time is up. Thank you, Your Honors.
Thank you very much. And all your time is up. I'm just going to double check with the panel to see if they have any follow-up questions for you. And I see none. So thank you very much for your argument. We'll turn now to Attorney Payne.
Good morning. May it please the court. Assistant District Attorney Cynthia Payne for the Commonwealth. The Commonwealth is requesting that this court affirm the defendant's 14 convictions. Starting with the defendant's first issue, the trial judge properly denied the defendant's motion to sever the charges involving SS from the charges involving AG. And here there were 7 shared characteristics. Overall, the Commonwealth's theory was that the defendant was involved in sexual exploitation of these 2 females. So we have 2 females, both females, they're both from Holyoke. There's the use of the Facebook medium. There's the use of Crystal, who reaches out to both individuals, neither of whom know Crystal. There's the lure of the high-paying modeling job. The charges involving asset, the time overlaps. So the defendant exploited AG from 2014 through 2016, and both extorting her for both sexual favors and for money. The charges involving SS occurred during that time in late January, early February of 2016. Here, the location is the same. The defendant raped SS in AG's apartment, and even I would say certainly it's reasonable that there's a reasonable inference that the location is the same, even piecing together, even if we take what my sister has said, that nobody other than AG was able to provide that address. I would suggest piecing it together. We have Detective Williams, who after SS described the area was able to, he was able to figure out where the location had taken place. He determined it was 34 West Court. He went to 34 West Court and spoke to AG, and that's where the 2 sort of overlap. Then we also have the means of abuse, because here when both SS and AG balked and didn't want to continue, the defendant threatened both of them with exposure. And I would suggest that those are 7 shared, very unique characteristics in which and why the motion judge properly denied the defendant's motion to sever, I would refer the court to the case of Commonwealth versus McGree. That was cited in my brief, a 2012 case. It affirmed in part, and there the court found that the joinder of 32 separate charges for trial showed a pattern of operation, despite the fact there were different victims, different crimes, different times, different locations, but overall it shared enough characteristics to show a pattern, just like in this case. I would say that the defendant also failed to show undue prejudice resulting from the joint charges. Here, I know my sister has indicated that he was foreclosed from pursuing a misidentification trial, from a misidentification defense. And certainly, as Justice Hanlon, as you had indicated, identity is certainly something that can be shown through related offenses. But here, any misidentification defense would have been weak at best, where the jury heard, the defendant's identifications, out-of-court identifications, the two pictures that SS would have come into evidence as they did. The jury heard the defendant's statement. They heard the defendant's voice in the consent video, in which he's ordering SS to say what he wants her to say. So I would suggest that would have been a very, very weak at best. And just because he would have had a better chance of acquittal if the cases were severed, that does not constitute sufficient prejudice. I'm sorry.
Do you want to say something about the dissemination argument?
Sure.
I don't know. I didn't mean to cut you off if you were still in.
No, that's fine. Did you have a particular question?
Just why is it dissemination? Your sister argues it's not dissemination because he sent them only to a consenting person. Is that dissemination every time people take those photos and send them to the other participant?
Well, I would suggest here, because she's a minor, certainly the statute, the section, I believe it's D, a person, a minor can't consent. And I know that's slightly different, but she certainly has the benefit of the statute. But I would suggest that
so every time, every time two teenagers engage in sexual relations and take pictures and then send them to each other, that's dissemination?
Well, I would suggest that possibly. However, the legislature has not added language indicating that it's not. It is not indicated there has to be someone other than the person. You have to send it to someone other than the person depicted in the picture. And here, because we have a minor, I would suggest that certainly that because we're not adding language, you can't add language to the statute that it would qualify.
And isn't there also the element of lascivious intent? You'd have to show that as well.
That's correct. And I would say certainly the very graphic nature of those pictures, which indicate exposed genitalia, the very focal point of those pictures, including I would just suggest the very sexually graphic nature that would show the lascivious nature. And I would also, if you want me to go down that whether or not the Commonwealth proved the lascivious intent, certainly the fact that the defendant sent those pictures along with previously sending the picture of the hand holding the money, certainly he wanted her to come back and continue having relations with him. And I would suggest in sending that to him, sending those collages that he produced, that had her name, that were the pictures that were taken, that she had taken both at her own residence, and he had taken of her by sending those to her, compelling her. I would suggest that certainly he had his own sexual gratification in mind, and certainly in the light most favorable to the Commonwealth, the Commonwealth did meet their burden on that charge, on those two charges.
Okay. Can I ask a question about the hearsay argument?
Sure.
So you argue that there are no hearsay concerns because the photographs are not statements. But I'm not sure that's the right inquiry, because isn't the question whether the report itself is hearsay?
Well, I would suggest the testimony was that you could see the pictures, and I would suggest that the pictures by the very definition are not statements, and this is not
right. But the report isn't in evidence, right? So if the report is generated by some sort of human input, human action, right, then doesn't that make the report itself hearsay, because it would be what the SJC has called a computer, is it a stored record as opposed to computer generated?
I understand what you're saying. I would still maintain the fact that because the officer, the person who's testifying, he saw the pictures on SS's phone. He saw the collages that had been sent. So he also did see those pictures in the report, but the fact of the matter, he did see those pictures.
But he didn't see them on the defendant's phone, right? So the only evidence that they were on the defendant's phone is the extraction report.
Yes, but again, I think because they are pictures, he can look at that report, and because it's a picture, I again.
No, but I mean, do you understand my question, that if the report is generated through some sort of human inputs, then the case law says that does implicate hearsay concerns, right? As opposed to computer generated. So you had a detective who testified as to how the report was generated. Is it your position that that testimony is enough for us to say that this was a computer generated report?
Yes, I would have to say that is enough, because we have Sergeant Savigny who went through what he had to do to go to. Essentially, he just plugged that phone into a computer and it extracted. He didn't, other than plugging it in, he didn't have to and clicking one query button. He wasn't inputting anything. So I would suggest, based on that as well, that was not impermissible.
Okay.
I would like to note that in the Commonwealth's brief on page 29, discussing the motions in limine, I erred, and the citation to the motion in limine should be to volume 4. I wrote volume 5, so in a number of places on that page. I apologize. I caught that as I was prepping for argument.
We found it.
Unless the court has any further questions, the Commonwealth would rest on its brief.
All right, just one moment, and I'll check with the panel to see if they have any follow-up questions for you. And I see none, so I want to thank you both very much for your argument. It was very helpful. We appreciate that. We'll take the case under advisement, and we'll get back.
And we are back live and on the record.
Okay, thank you very much, and good morning, and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel to you. My name is Ariane Vuono, and I'm joined today with Justice Sidney Hanlon and Justice Young Shin. I'm going to call the case in a moment, but just 2 quick reminders. You each have 15 minutes to present your case, and there is no rebuttal on the Appeals Court. And we don't want anyone to panic if we have any technical difficulties. Sometimes we do, and they're usually resolved fairly quickly. And I just want to assure you that if it does happen, you will not lose any of your time. We will pick up and we will make sure that you haven't lost any of your time for your argument. Okay, so today this case is Commonwealth versus Walker Browning, 2020-0240. And Attorney Bachrach, we'll hear your argument.
Thank you very much, Your Honors. Good morning, and my name is Barry Bachrach, and I represent Mr. Walker Browning. I'd like to first address the issue of whether the police seized the bus in a constitutional sense and whether or not they had reasonable suspicion to do so. In order to do that, I think it's important to set the scene. It was about 11 p.m. at night in the Mattapan area. The two officers were in their patrol car about 20 minutes after a call, searching for a suspect. They were driving along and saw a bus coming in the opposite way. They did a U-turn and they followed the bus. They followed the bus until.
Just let me interrupt you just for a second, because
Sure.
I just want to be sure that we're all that we are on the same page with the facts. So the judge specifically found that when Detective Sloan turned the car around and followed the bus, he did not turn on his blue lights or attempt to stop the bus.
Correct,
It's an
Your
unmarked,
Honor.
it's an unmarked vehicle, right?
It was an unmarked vehicle, Your Honor. Correct.
No
But-
blue lights, no wigwags, as they say.
Correct. Correct. But I think the important is they follow the bus and the bus turns into a designated stop. At that point, the police are driving by the bus, and the judge finds as they pass the bus, they saw a black male who was slumped down with the hood of his gray shirt occluding his face. Based on that sighting, a black male slumped down with the hoodie covering his face, the police pulled their car at an angle in front of the stopped bus.
See, that's where I have some problems.
Let one officer off and then park a couple of spots farther on, right?
Well, that's unclear, but Detective Fogarty.
Both of the police officers testified that they parked a couple of spots up on Blue Hill Avenue, right?
Okay, Your Honor, and I think, and with all due respect, I think I agree with you. But I think the fact that they pulled the vehicle, blocked the bus initially, let Detective Fogarty out. Detective Fogarty then gets on the bus and he flashes his police badge. It's on his buckle, and the judge found it was prominently displayed on his belt, and he greeted the driver. Detective Sion.
He only flashes it to the driver, though. Would you agree with that?
Correct, but the driver is the important person here because the driver is the one driving the bus, and in order
Why is the driver the important person as opposed to the passengers?
Because it's I analogize this to a vehicle, any vehicle stop. When the vehicle is stopped, all the passengers, the driver and all the passengers are treated the same. And here,
Well, if a reasonable passenger would have felt free to get off the bus, I don't see why we're analyzing it from the viewpoint of the driver.
because I think from the viewpoint from the driver, because the driver's operating the bus. If the bus was detained from continuing on its schedule, then there's been a stop.
Is there any evidence that the bus was in fact detained from continuing it on its schedule, or is it your position that just getting on the bus with the badge, even in plain clothes, at its regular stop, that's a detention?
Yeah, yes. It would be different if we were at the stop that was scheduled and the bus driver gets off and or if it's at the end of the route, if the police had followed him to the end, the bus to the end of the route.
But so everybody else can get on and off, but the police officer can't.
I'm sorry, everyone,
Well, it's a major intersection, right? It's Morton and Blue, right across from the police station. And and other people can get on and off. And in fact, there was testimony that 2 people did.
no,
But the police can't get on that bus even though it's legitimately stopped?
no, that's
They
not.
like if he had paid, would it be different? Instead of flashing his
That's not what I'm saying. And as far as people getting on and off the testimony, there was 2 people there. They weren't sure whether they hadn't gotten on. They were just standing at the stop, and they were still standing on the stop when the police left. And it's
so what I'm saying is it the fact that they were police officers, or that they had a badge, or that they didn't pay, that made his getting on a stop?
It was the fact that they were police officers showing authority. And the second police officer who gets on page 130 to 131 of the transcript testified that yeah, we kind of told him to hold on. And so you had one police officer enter the bus after a car is stopped here, the bus like this. One Detective Fogarty comes on, flashes his badge, and then Detective Sion comes on and he testified, we told the police to hold on. We told the driver to kind of hold on. So what my position is, the police showed their authority, and their authority was to keep the bus from proceeding.
So how could the officers have boarded the bus without transforming it into a stop? What could they have done less intrusively, in your view, that would not transform this into a
I think what the police officers should have done was continue to follow the bus until either a suspect got off, or they could have followed it to the end of its route. And if the suspect was still on, at that point, if the bus is stopped and not going to go any further, they could have entered the bus. So, I mean, the least intrusive would be to keep following the bus, because here they actually physically stopped it and detained it.
So they're looking for somebody, I'm sorry, I have asthma.
It's okay, Your Honor.
Cough drop.
It's okay.
They're looking for somebody who's just robbed somebody. And there's time is of an essence, right? You're in the area, you're looking, it's a lot of streets going right around there, right?
Exactly.
So they should just follow along and hope that eventually the bus will stop right when it gets back into town. That's got to be, Google Avenue is a long street, right?
Or if they're remarked, the fellow might have they follow it until the suspect gets off, and they approach him at that point.
And is your view that at that point in time, the officers could simply approach him and talk with him and would not need reasonable suspicion or probable cause or anything like that?
No, if they had seen him, because it wasn't until they got onto the bus
that they recognized his
Detective
face.
Sion recognized him, that they saw the North Face backpack and they saw his shoes and recognized him as had articulable facts to recognize him. They had no.
Presumably, not to interrupt, presumably when this person exited the bus, your view is they would have then noticed that knapsack and the shoes, and that would have been sufficient for them to have approached him.
Correct, because then they could have had specific facts that allowed them to have a reasonable suspicion. Here,
So there's no way for the police to initiate a consensual encounter on a bus or some other form of public transportation. They have to wait until the person they're interested in gets off.
Again, Your Honor, it depends. If the bus is on its route and proceeding, And even at a designated stop where people are coming on and off, it's our view that they need to have a basis, a reasonable suspicion to go on and do a search.
So had the defendant not gotten on the bus, the officers would be free to approach him on the sidewalk and initiate a consensual encounter. But the second he gets on the bus, now that becomes a safe haven for him, and the officers can't approach him.
I think the difference is, Your Honor, if they had driven by the bus and they recognized him, or they saw his North Face backpack, or they saw something.
So you're saying that in order to question someone who's on a bus or some other form of public transportation, the officers always need reasonable suspicion, that there's no way for them to ever approach someone on a bus and have it be a consensual encounter. I mean, do you see the problem? I have a real problem with that.
Well, Your Honor, I'm not saying you can never. There's a series of United States Supreme Court cases where they were doing random drug interdiction, and the court, the United States Supreme Court in Boston, for example, said yes, the police can go on, and the bus there was at a stop. It was a Greyhound bus or something like that, and the police, the bus driver got off the bus. The police were allowed to go on at that point. But so there's times and places where you can go on and move, but moving vehicle.
But these officers didn't stop the bus. They got on at a scheduled stop, right? I mean, I guess I'm having trouble seeing what they could have done differently to make the encounter less intrusive. And if we accept your position, it does seem like you're saying that there's no way to have a consensual encounter on a bus. I also think there's a difference between a Greyhound bus, by the way, and a city bus, because on a Greyhound bus, presumably you're going a longer distance, you've bought a ticket. And I think a reasonable person would feel less free to get off the bus. Whereas if you have a city bus making regular stops every few blocks, someone could just get off the bus, right?
Right, and the police then, when you get off the bus, would have the ability to make a determination. Here, that was just Your Honor, it was just a pure hunch. The reason they followed the bus was because of on a prior incident, one of the prior alleged robberies, the suspect had attempted to get on a bus, but didn't get on a bus. So,
and because there had just been a robbery in that, admittedly farther down Blue Hill Avenue, but there had just been a robbery in that area within the previous 20 minutes, right?
Right. And there was the Commonwealth didn't introduce any evidence as to what bus they had attempted to get on before. And there was testimony on pages 83 and 84 that there were other buses in the area that have routes. And there was also testimony that at the various other robberies, the robber took different routes. And so it was purely a hunch. They turned the car around.
We're at reasonable suspicion, right? Not even more likely than not, you got the right guy, which would be preponderance, right? We're at reasonable suspicion, right?
Reasonable suspicion, but it has to be based on some facts. The only facts here are that he was as the judge found, they saw a black male slumped down with the hood of his gray sweatshirt, occluding his face as they drove by the bus.
With approximately the same build as the robber, because the other guy, no, that's a big guy. He's at least 6'3". Couldn't be him. And then there's a woman, and there's only the three people around. There's somebody who fits the build description, right?
Well, Your Honor, that I don't see how they could do that, because he was slumped over. I just don't see how the police could see how his height or build that well when he's slumped over. They couldn't see his complexion. They couldn't see his age. the judge found, judge found that he slumped down with the hood of his gray shirt, including his face. And so and I agree, reasonable suspicion doesn't require much, but it requires some articulable facts. This was a pure hunch. Whether they made the right choice or not will determine if there's a trial, but they had a hunch. And
Attorney Bacharach, I'm going to stop you there only because I think you've made that, we understand that point, and you've made it well today as well as in your brief, and actually your time is up. But I did want to ask you two other questions about the record in this case. No, I have two other questions for you that are a little, and if they're in the record, you can answer them, and if they're not within the record, you can tell me. But I noticed that there were a number of bail reviews on the docket, and it looks to me like your client is still incarcerated. Am I correct, or is there anything more recent on the docket that indicates something different?
It was my understanding that he was released to his home at least about a month ago when I had been.
I see. Okay, that's why I didn't see that on the docket. Okay, thank you. And I also saw that there was a competency hearing that was scheduled for your client. And is there anything in the record? Was anything filed with respect to whether or not your client is competent to stand trial? If you
there was, Your Honor, could I supplement that? Because I know I recall things. I didn't study it for today because I wasn't
sure. And again, I'm only asking questions that was something that would be in the record. Perhaps the Commonwealth can answer the question anyway. So we'll leave it at that.
Okay, thank you, Your Honor.
Okay. You're welcome, and thank you very much. And you did not have an opportunity to speak about the photo identifications, but don't worry, we will address that anyway. That's also been well briefed, and so we can address that later. Okay.
Thank you, Your Honor.
You're welcome. Attorney McLean, is it McLean or McLean? How do you pronounce your name?
McLean, Your Honor.
McLean. Okay, Attorney McLean, please start.
Thank you. Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. Your Honor, this court should affirm the motion judge's ruling denying the defendant's motion to suppress for three principal reasons. First, the detectives did not stop the defendant in the constitutional sense merely by boarding the bus at a scheduled stop. Second, if you assume arguendo that they did stop the defendant by boarding the bus, they had a reasonable suspicion to do so. And third, the photo arrays that were used to identify that the defendant was identified from were comprised entirely of booking photos and were not unnecessarily suggestive in any way. Your Honor, turning first to the question you just asked opposing counsel about anything in the record regarding competency, I'm sorry, but I am not familiar with anything in the record, but I will look, and if there is anything, I will file a 16L to bring it to your attention.
Okay.
So beginning with the question.
Let me ask this: Did you also understand from you're familiar with the case that the defendant is no longer incarcerated, is no longer being held?
That is my understanding, Your Honor.
Thank you.
Turning to the question of the initial interaction here between the detectives and the bus itself, merely boarding a bus does not constitute a stop in the constitutional sense. So I'd like to take a little bit of issue with some of the characterization of the testimony that came during opposing counsel's argument. You referenced at an angle once during his argument and that the bus was blocked in initially. The judge didn't make any such finding of fact, and there isn't any testimony that would support a factual finding that the unmarked squad car was pulled in at an angle blocking the bus in. The testimony was simply that the car drove parallel to the bus, stopped at about the front driver's side tire of the bus. The detective in the passenger seat exited the bus. As the detective from the passenger seat walked in front of the bus and boarded the bus, the driving detective, Detective Sloan, drove up the street a few spots and parked the car, and then followed his partner, Detective Fogarty, onto the bus. So there is no testimony that would support a claim that the officers used their unmarked squad car to impede the bus or to block it in at its scheduled stop. That's the first important distinction to draw. Then second, the question then becomes, did the detectives stop the defendant himself by simply boarding the bus and showing the bus driver their badge?
I'm sorry to interrupt, but could I just ask a preliminary question? The judge didn't really address the question of seizure. There's a footnote where the judge notes that the police did not stop the bus. That seems to be uncontested. But otherwise, I don't really see any findings on the question. Is there any reason, or would a remand serve any purpose in your view?
No, Your Honor, because regardless of what ultimate conclusion the motion judge had made about when a stop occurred, if a stop occurred, that'd be a conclusion of law that this court would be reviewing de novo. So the only question for you would be whether you had adequate facts to make that determination yourself. And here, the motion judge expressly credited both of the two detectives were the only two witnesses that testified. So that basically incorporates all of their testimony as factual findings because the credibility determination has been made for you. So as long as you find that there's sufficient information within their testimony for you to evaluate the question of whether a stop occurred, then we're all set and there's no need for a remand. And respectfully, Your Honor, there's plenty of testimony here from which you can make that determination. We already sort of discussed how the squad car pulled up alongside the bus, the detective exited and boarded the bus, how the squad car parked. So now we're to the point where we're talking about the first detective, Detective Fogarty, boarding the bus, and whether that would then constitute a stop of the defendant. And the testimony there that you have are that as he boarded the bus, he showed the bus driver his badge. That's at transcript 73, and his badge was on his waist as it was when he testified, transcript at 30. And what he said to the bus driver as he boarded the bus was, "How you doing?" That's transcript at 30. So that becomes our question. Does it constitute a stop in the constitutional sense of a passenger of a bus if an officer in plain clothes boards the bus, displays his badge to the bus driver and says, "Hey, how you doing?" Respectfully, the answer to that question is no, it does not, for several reasons. First, the legal question is controlled by MATA. So the test comes from MATA. So the test is, did that officer communicate objectively through his words or conduct that he would use his police power to coerce the defendant to stay? So first off, Justice Shin, as you pointed out during my brother's argument, the interaction was with the bus driver, not with the defendant. So that would answer the question right there, that no, the defendant was not stopped in the constitutional sense, by Detective Fogarty interacting with the bus driver. Second, even if you were going to bypass that question and consider the interaction with the driver the same as the interaction with the defendant, still merely displaying your badge and saying, "Hey, how you doing?" is insufficient to establish a stop in the constitutional sense. And I point you to a series of cases there. Evelyn, merely identifying yourself as a police officer is not sufficient to be a stop. MATA, it was not a stop where a uniformed officer said, "Hey, come here for a minute." Stout, a uniformed officer saying, "Hey, hold up a minute," not a stop. And then Rock, not a stop for an officer to exit his squad car, identify himself as an officer and ask, "Hey, can I talk to you for a minute?"
But
So
isn't the MATA standard somewhat imperfect in the bus context? Because let's say that the officers were on the bus and the bus was moving, right? If we apply the MATA standard, it's whether a reasonable person would feel as though the officers would coerce him to stay, but on a bus that's moving, they wouldn't be able to leave.
I understand your concern, Your Honor, but I then point to specifically MATA 363 that says the question of whether a person is stopped or not has to come from the officer's actions. So in your hypothetical situation there, you're sort of incorporating the bus driver's actions as well. And MATA expressly tells us that we can't do that. It's the officer's actions that determine whether it constitutes a stop.
No, right. So that's what I'm saying, that that MATA actually just it doesn't account for this situation. In other words, even if someone on a bus that's moving would not feel as though they could get off the bus, that doesn't necessarily mean that it's a seizure, because it's not the officer's actions that are compelling them to stay on. Right. So it seems like there has to be a tweak of the standard in this kind of situation.
Respectfully, I don't believe there does need to be a tweak of the standard, Your Honor. In your hypothetical, the person could get up and move to a different portion of the bus or tell the officer they were not interested in communicating with them to end the encounter. So that's how I would suggest the hypothetical you just suggested would be handled. But the factual situation here is distinct from the hypothetical you just described. And I point you to, there were two passengers at the stop that were going to board the bus. And you can find that at transcript 110, 129, and 133. So this bus was parked at a regularly scheduled stop, conducting the business of a public MBTA bus, as the detectives boarded the bus and walked down the aisle to get a closer look at this suspect that was on the bus itself. So here there simply isn't anything from which we could conclude that the officers blocked the bus in or that the officers stopped the bus itself. It was conducting its normal business. So here,
what about the statement to hold on? How does that factor into the analysis?
Well, respectfully, Your Honor, when Detective Fogarty boarded the bus, that was the first detective on the bus, what he said was, "Hey, how you doing?" And that's transcript 30. What opposing counsel is referring to was the second detective boarding the bus, and he's referring to transcript page 130 to 131. And I'd encourage you to take a look at those two transcript pages and take a look at the transcript page before that, 129. On 129, what Detective Sloan said when asked what happened when he got on the bus, he expressly said he did not talk to the bus driver. That's transcript 129. Asked a follow-up again, he said, "No, I did not talk to the bus driver. I didn't talk to the bus driver."
Right, but then he was impeached with his, I believe it was his grand jury testimony when he said that he did say to hold on. The judge didn't make any findings on it because she passed over the question of seizure.
Correct, Your Honor. Correct, Your Honor. He conceded or assented to a synopsis of his grand jury testimony. We don't know exactly what the grand jury testimony was. It was sort of a summary or a synopsis by the defense attorney that was cross-examining him at the time. But even if you were to accept that exactly what he said was, I've forgotten the phrase, hold up a minute, I believe it was. Think about in the sequence of events, in the timeline of events here. They pull up their unmarked squad car and stop it. Detective Fogarty walks in front of the bus, boards the bus, walks to the back of the bus, and then begins walking back towards the front of the bus. As those things are happening, Detective Sloan drives up a few spots, parks the car, walks back, and then boards the bus himself. So during the time that Detective Sloan was doing that, Detective Fogarty had engaged in already walking to the back of the bus and walking towards the front of the bus, at which time he saw the north face backpack. So if Your Honor was to decide that when the second detective boarded the bus and that statement was enough to constitute a stop of the defendant, then we have to evaluate whether there was reasonable suspicion to justify that stop. So we'd freeze it in time right there and evaluate all of the facts that we have. And I would suggest there are a series of facts from which you could find that the officers had reasonable suspicion to stop the bus. I would start with the description from this particular 911 caller. It was not a particularly detailed description, but there was a description of her armed robber who actually stabbed her, didn't just rob her at knife point, but stabbed her. And you can see that she was stabbed at transcript 19. That description was a black male of medium build wearing a hoodie with a mustache. That's at transcript 76 to 77. So not a particularly detailed description, but under the Manousis case, even a scant description is something that can factor in when the officers have additional information. So here the officers had a whole lot of additional information. This was the 9th armed robbery within a period of a couple of weeks where the suspect they had developed was a consistent suspect. It seemed to be the same person. And this general description is consistent with that suspect. Now they saw this suspect on this MBTA bus, which is a means of that their suspect had previously used in one of those 8 prior robberies to try and escape from the area of having just committed an armed robbery. So now we have someone who's consistent with the description given by the current victim, matches the description they have from the series of other robberies, using the means to escape the scene that he tried to use in the past. Now we add in the fact—
on one occasion, only on one occasion though, right?
Yes,
there were 8 priors and 8 prior robberies, and there was just one time when allegedly he escaped on a bus.
Yes, Your Honor. Granted, surveillance video doesn't capture all of Boston. Sometimes in law enforcement we wish it did, but from the surveillance video, they were able to see from the 8 prior instances on one of those occasions, he tried to get away from the scene by boarding a bus.
I'm not saying he did it in other times. I'm just saying in terms of what the officers knew here, they knew that it happened on one occasion.
Yes, Your Honor. Yes, Your Honor. But you also want to add in here that this area was saturated with officers as a result of these series of robberies at the time. So we have an area saturated with officers where they have not identified a suspect. And this robbery is consistent with the suspect from the previous robberies because all the specifics are the same, in the same general area between the MBTA T stop.
But the description that was given by the 911 caller was that he was wearing a jean jacket and a black hoodie, right? And so the color of the clothing didn't match. She also said he had a mustache, but at least at the time that they stopped the bus, the officers couldn't see the man's face, right? So it seems all you have is a black man with perhaps matching the build, had the same build, maybe the age, I don't know.
So yes, Your Honor, I'll agree with part of your synopsis, but not all of it. I think that the characterization of it as a black hoodie came from the defense attorney, not from any of the witnesses. My understanding of the witness testimony is the officers understood the description was a hoodie, not a color of the hoodie. Okay. Second, a jean jacket can easily be taken off. Just because the victim said he was wearing a jean jacket when he robbed me and had a hoodie on underneath, it doesn't mean you're going to find him necessarily.
But I'm just trying to ascertain what parts of the description matched what the officers saw at the time they stopped the bus.
So 3 things, Your Honor. Race, black male, transcript 28. Stature, 5'7" to 5'8", slight build, transcript 28 to 29. And that he was wearing a hoodie, transcript 28.
How can you tell his stature?
Your Honor, as they drive by an MBTA bus, the windows are ginormous, for lack of a better term, on an MBTA bus. It's after 11 o'clock at night, MBTA buses are lit. So basically a person sitting in a bus is in a fishbowl at 11 o'clock at night. You can very clearly see the people that are in the bus. They could determine that the other male occupant of the bus was clearly too tall to match their description, suggesting he was probably 6'2" or 6'3". This defendant roughly matched the size of their suspect. So I'd also like to point out quickly, because I'm running out of time, we also have geographic and temporal.
Sorry, we're going to we'll give you time to, I expect Justice Vuono will give you time to finish and answer my question, but that male was looking straight out the window, right? The 6'3" person was looking straight out the window. And that was the other person who was slumped down with the hoodie and his head down, right?
Correct, Your Honor. Correct, Your Honor. But again, the motion judge credited the officer's testimony, so we accept the officer's testimony as true. And the detective testified to the 3 specifics, 3 particulars: the race, black male, the stature, 5'7" to 5'8", slight build, and the hoodie. So those are the consistent portions of the description that match. But the description doesn't have to get us there alone, because we're just talking about reasonable suspicion. So here we have consistent, basically MO of this crime, someone that matches the description, using the means of escape that has been attempted to be used at least once before. We have geographic and temporal proximity, and I point you to DePina and Ducey to look at how that can factor in. And then we have the ongoing nature of the public safety risk here. This was the 9th armed robbery, and this one involved a stabbing. So all of these things factored in together collectively. And as the Edwards case points out, we have to
I'm going to have you rely on your brief from here on in, and you got a lot in the last couple seconds there, and we heard you. I want to thank you both very much for your arguments. It's an interesting case, and of course, a lot at stake for the defendant and for the Commonwealth. And we appreciate you answering all of our questions, and we appreciate your detailed briefs. We'll take the case under advisement, and since this is on an interlocutory appeal, we'll do our
And we are back live and on the record.
Okay, thank you very much, and good morning, and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel to you. My name is Ariane Vuono. I'm joined today by Justice Sidney Hanlon and Justice Sik-Yong Shin. I would like to give you 2 quick reminders before we start today, which is that each side has 15 minutes and there is no rebuttal in the Appeals Court. And we've had no technical difficulties so far today, so let's knock on wood that we don't have any during this argument either. But if we do, just please be patient. I can assure you they get resolved pretty quickly, and no one will lose any time in terms of their argument. Okay, so with that said, I'm going to call the case officially 2020-0726, 15 LaGrange Street Corporation and others versus the Massachusetts Commission Against Discrimination and another. And Attorney Merrill, please begin your argument.
Thank you, Your Honor. Thank you to the panel for being here. I'll note offhand a little bit to start with. I got to improve my background. I see everybody else's is much better than mine. I apologize for that. I hope it's not distracting.
Yeah.
Judges, I mean, you have the brief, and I think that outlines pretty carefully what we want to say and what our positions are on the legal issues and on the factual issues both. I want to start here by pointing out just kind of as an overview on some of the issues, what we see from this point of view. And I want to do that with, I think, a pretty strong word, but I want to use advisedly. And that is that this decision by the MCAD below and what's happened up to this point is a travesty. I don't know how else to describe it. and I'm going to explain why we feel so strongly about that on this side. We think that there is extreme bias shown at the MCAD level by the hearing officer, and I think that jumps out from her written decision. We think that the decision on at least one part of this, and I will acknowledge one part is stronger than the other, and that is on this question of why Mr. Sims, the complainant, was fired, is unsupportable. It's unsupportable because it should have never been heard. It's unsupportable because, frankly, Mr. Sims doesn't even claim he was fired because of his race. He never did. And it's unsupportable because there is no evidence to support the conclusion that the hearing officer made, no viable evidence, that this was a termination based on race. Mr. Sims, in fact, contended from day one, starting with his complaint, until the end, at the hearing, that he was fired in retaliation for complaining about sexual harassment.
Well, actually, both you and Attorney Sullivan, in your opening arguments before the hearing officer, talked about the fact that there was an allegation that he was terminated because of discriminatory intent.
Well, I won't speak for Ms. Sullivan. I'll speak for our side, and I'll say to you that if you looking through the record, you'll see that we repeatedly raised this issue, and the reason we raised it is highlighted, I think, by the fact of what Ms. Sullivan said at the outset of the hearing. When at the beginning of this, and I think this illustrates the point, Judge, I asked the hearing officer at the start of this hearing, let's get clarity on what the causes of action are. And the reason was we had a whole bunch of issues about race, and we had some kind of nebulous, suggestive language that there might be some race relationship between race and firing, but never a claim. I raised that in the pre-hearing memorandum.
But I see it was addressed before the hearing officer, and now you're saying that this is sort of new to you at this point.
Well, I don't know what you mean, Judge, by addressed before the hearing officer, because she never addressed it. I raised it at the beginning of the hearing for that reason, because I still didn't know what they were going to claim with any certainty. I know what they said, and I can see what Ms. Sullivan said. I'm looking at it, and this has been cited in the brief by Ms. Liebman and by Ms. Sullivan and by the full commission and by the court, all saying the same thing that she referenced when asked this question. When she asked, she said, we have a hostile work environment claim based on race. And that was up until the time of termination, and that race played some role in the decision to terminate, but the second claim is retaliation. Now, this is what's always cited. This is what's cited by Ms. Liebman, it's what's cited by Ms. Sullivan, cited by everybody. What they don't do is read the next paragraph, which says, quote, so there's essentially two claims: a hostile work environment based on race up until the time of termination, and then the termination being based on retaliation. Two claims. Now, if you look at the hearing officer's decision, obviously, she goes through three claims. She adds termination based on race. If you look at what Mr. Sims testified to, and this is inaccurately reported by the hearing officer as well, he said he was fired because he complained to Michael Bennett about sex harassment by another bouncer and was let go, the pretext being he left his post early, which he said he never did, in a phone call from a gentleman named Danny Wong, who told him, Nick Romano says you're asking too many questions, you're fired. Hearing officer didn't believe that, rejected it. Hearing officer didn't believe that he reported to Mike Bennett that he anything about sex harassment, said he didn't. Hearing officer made a whole slew of other factual findings indicating that Mr. Sims lied on certain points. That was one of them, or there was two of them. Another one was whether or not he was stationed outside on a regular basis, or that was racial in any event. Mr. Sims had said in his complaint, this complaint being, of course, a sworn statement that he was at hearing something different. He said he didn't know if that was racially based. And he testified that at one point he was inside with Mr. Romano when Mr. Romano fell asleep at the bar. Mr. Sims said he wouldn't let me up because I'm black. Hearing officer found that wasn't true. Hearing officer found he wouldn't let him help up because he was embarrassed. He fell asleep at a bar. He's an old man, and he was embarrassed, and he'd get frustrated because this happened.
And let the white customer pick him up.
I'm sorry, Your Honor?
And let the white customer pick him up instead.
Well, he let somebody pick him up, and yes, you could. That is what Mr. Sims said. I don't think that's what the hearing officer found. I don't know if she found anything on that topic. I'm not disputing that fact. I don't know the answer to it. But what I'm saying is that that's not an indication of racism. And I think most importantly for what I said at the outset of this, where we're going with this and what the claims are, and that this is an example of extreme bias by the MCAB, that has absolutely nothing to do with this firing. That was an event that happened sometime during the employment of Mr. Sims, but was not connected to fire.
Were we to agree with you that your client wasn't on notice of a claim, a termination claim based on race, what then is the analysis on prejudice? What kind of showing is required? Or is there any showing of prejudice required on your part?
I'm sorry, are you asking, do we have to show that there was prejudice?
Right, so let's say you were not on notice of the claim. Is there any showing of prejudice that's required? Any specific showing of prejudice? In other words, for instance, we would have done this different.
I understand. Right. Yeah. No, I don't think so. I think what the case law says, and that I've cited, is that we need to be put on notice and have a fair opportunity. And I grant you that's a judgment call. If the court were to conclude, all right, Merrill didn't know, effectively, respectfully, I'd say this about myself, then you're saying Merrill's an idiot because he didn't have any idea this was coming up. Because I honestly didn't, and you can see that from the paperwork, the brief, and the question I asked from what I just read. You could still conclude if you wanted to, there wasn't prejudice. We still had a fair opportunity, I suppose. I think the issue is, you need to get notice so that you have a fair opportunity for argument to submit evidence. I'm going to tell you that we didn't, and I'm going to point to the fact that the conclusion on race discrimination, the argument, the conclusion, I should say, not an argument, the argument that the hearing officer made, conclusion that the hearing officer made that there was pretext was that no white bouncers were fired, right? That 3 black bouncers were fired. And what I would say to you on this topic is, if I knew that was coming, which I didn't, if I knew race was coming, which I didn't, if I heard even Mr. Sims say at hearing, even after not knowing about this, if he had testified, I think I was fired because I was black, here's why, look what happened to Simmons. Simmons is the guy he accused of sex harassment. He's one of the 3 who was fired for a completely unrelated reason, but he was fired. I would have said, hold on, time out. I need a break in to come back, and I'll bring you evidence of what happened with white bouncers. Because that appeared to be the direction that things were going, or would have appeared, I'm sorry, if he had said that, but he didn't say that. He never contended that he was
But you've never made any offer. I mean, this is the first one, because what I was just going to ask you is what would you have done differently? There's never, I don't see anywhere, did I miss like an offer of proof at any point or what you would have?
No, there was no offer of proof. And the reason is, what I just read you, there's 2 causes of action. And then I went through the whole hearing.
Since then,
and when I heard what Mr. Sims, I'm sorry, go ahead.
Since then, you've said repeatedly, we didn't know. And this is the first time I've heard there was something else you could have done or would have done had you had that notice from, had you believed you had that notice from get-go.
Right. Well, I'm saying in theory, I mean, Judge, I don't know the answers to who got fired when. I know that this was in the decision by the hearing officer, and Justice Shin just asked me about prejudice, so I'm throwing out a—
Yes, but you appealed to the Superior Court, and you didn't make this argument to the Superior Court judge either.
I didn't make an argument that there was prejudice? Or?
No, you didn't make the argument that to the Superior Court judge that the underlying decision was arbitrary and capricious, because you did say that you didn't have notice, but you didn't say, and because I had additional evidence that I would have shown.
Judge, I think I'm being misunderstood. I'm not saying I had additional evidence. I didn't withhold any evidence. I didn't make an offer of proofs. I'm just trying to answer Justice Shin's question.
Hypothetically,
why were you prejudiced? And I'm throwing out a hypothetical that I could have possibly done this. I don't know.
But if you didn't have that evidence, then you wouldn't have been able to do that.
Correct. That would be correct. I don't know
what
evidence.
I was asking whether when someone doesn't even have notice of a claim, whether a showing of specific prejudice is required. So is your answer to that question no?
Yes.
No. Okay.
Right. And the primary argument here goes to fairness. It goes to what the commission could do under its regulations, frankly. And I guess more importantly, and the reason I call this a travesty and say there's extreme bias here is, how are we sitting here? I've been practicing 25 years, Your Honors. I do not know how I am sitting here arguing that my client should not have been found to have racially terminated somebody who got on a witness stand, took an oath, swore in a complaint that he was fired because he complained about sex harassment, was told that by the man who fired him, where a hearing officer says, no, you didn't complain about sex harassment. You never went to Michael Bennett. No, Danny Wong did not tell you you were fired for asking too many questions. In fact, you left your post early, just like the employer said. And on several occasions, and I've recited several of them, the hearing officer found Mr. Sims did not tell the truth, didn't tell the truth about all of these things.
Well, I think what you're ignoring here is the parts of his testimony that the hearing officer found to be credible, and the parts of your client's testimony that also informed the hearing officer's decision.
Well, a couple of.
In other words, the claim of bias is an extreme one, and and one that not taken lightly. So you know, we do have the transcripts, and we have reviewed them, and it should we conclude that there was substantial evidence to support those findings. Of course, we can't supplant our own attitude with respect to any credibility determination, as you know.
Understood.
But that's what the hearing officer did have the opportunity to view both Mr. Sims and your client.
And she did find that certain of Mr. Sims's testimony was accurate. She credited some of his testimony. She discredited other parts of his testimony. She did the same, I guess.
Which is her she has the authority to do.
Yeah, she has the authority to do, absolutely. The question is whether there's sufficient evidence to support a finding of a termination based on race when you have a claimant who says, that's not why I was fired. I was fired because of a complaint about sex harassment that did not occur. And then to get to the other point, and the real point I want to make about biases, I want the court, if it would, to please look at the way the hearing officer treated the so-called inaccuracies in testimony. I've recited a number of them by Mr. Sims. These are her findings, not my assertions. He lied about these things. That's what she said. I don't think there's anything in the record regarding Mr. Romano, who's the alleged perpetrator here of this act. He did fire Mr. Sims, no question. But I don't think there's anything in there indicating that he lied about anything of any substance. The hearing officer does point to the position statement as an excuse for undermining the reason for the firing, including pretext. And that was, she looked at the position statement and said, well, that's a sworn statement. And in it, they also talked about Mr. Sims leaving his post, Mr. Sims visiting women on the second floor in the dressing room when he shouldn't have been. And that shows that their reason for firing, leaving his post, was not the real reason.
But she explicitly disbelieved two of those three things, right?
She concluded
I got that right?
Yeah, she concluded he was a good worker. She didn't necessarily disbelieve him, Your Honor, but she said at trial they didn't testify to the same thing. So she contrasted the position statement, which said, gave a few other examples of his poor behavior, with the hearing testimony, which was he was a good employee. There was no dispute that he was a good employee up until the time he left. So based on that, therefore, she says, pretext. The real reason for the firing wasn't that he left his post, even though she'd already concluded that it was the real reason, and on retaliation basically said the same thing. And my point here is that she takes that one issue, and this is where the real bias, I think, is highlighted. She takes that one issue and says, I'm going to hold that against the respondents. I'm going to blame all the respondents. Bennett, by the way, who had nothing to do with any of this, she still finds responsible. But when it comes to Mr. Sims, who signed a sworn complaint, which she found on a number of respects was inaccurate, no problem. I'm going to take the things that I like about what he said and the things that I don't like, the absolute lies, her words, not mine.
But that's what you do in assessing credibility, right? Is you decide, we tell the jury, you can believe some of a witness's testimony or all of it or none of it.
Of course, but that's not my point. I mean, almost all of what Mr. Romano said, and I see my time has expired. I'll stop when the court tells me, but
just finish your point, please.
Yes, she is treating Romano as a culprit, as a discriminator because of an inaccuracy, so-called inaccuracy between the position statement and trial testimony. When there are numerous inaccuracies between Sims and trial testimony that she finds, not a problem. I'm going to believe the rest of what he says and conclude, by the way, very paternalistically, he doesn't know what's going on. He says he was fired for complaining about retaliation. He was really fired because Nick Romano's a racist. It was discrimination based on race.
All right. So yes, now you'll have, thank you. Now you'll have to rest on your brief.
I have
Oh, I'm sorry.
I have
Excuse
one
me, right,
question.
right,
I'm sorry,
yes.
it'll be very quick.
I apologize. I did not check with the panel like I
Mhm.
usually do. I apologize. Please go ahead.
Assuming we agree with you that you were not on notice of the termination claim, but we disagree with you on the hostile work environment claim,
Right.
that we find that there was substantial evidence to support that decision. Would
Yes.
you agree that the disposition would be to remand for redetermination of damages and fees?
I would, Judge.
Okay, thank you.
And I'm going to ask one more time if Justice Hanlon has any follow-up questions. Okay. Thank you very much. All right.
Thank you,
We'll
Your
now
Honor.
turn to Attorney Liebman. Excuse me, you're on mute, so just take a moment and get yourself off mute. There you
Good
go.
morning, Your Honors. Simone Liebman for the Massachusetts Commission Against Discrimination. May it please the court. The commission respectfully disagrees with the assertion that the club did not know that there was a claim for discriminatory termination. Throughout the process, at the complaint level, at the discovery level, at the certification level, during the public hearing, and even after the public hearing, it was very clear that respondents were aware of this claim. At the complainant specifically alleged that he was treated differently based on race. At the deposition, he was asked why he was terminated. And he stated, "I would never take race out of the equation." Romano could have said, "I don't like that guy anyway, let's get rid of him because I'm Black."
How
And
does
that's
this statement that he would never take race out of the equation show that he's raising a claim of race discrimination? I don't understand that.
He's
And
saying that
the complaint doesn't say anything about termination based on race.
the complaint that was filed by the complainant states that he was treated differently based on race.
Right, but I mean, I read the complaint, even reading it indulgently, I don't see the facts alleged in the complaint as raising a claim that he was terminated based on his race. So accepting that, if you just, I know you don't agree with that, but if you accept that, then where in this entire course of the proceedings was the employer ever put on notice that this was a claim?
I would say that the respondents were put on notice repeatedly over the course of the proceedings. In answer to your first question, Justice Shin, the question about him saying that, I believe that race was part of the equation when I was terminated is answering, I mean, it's a bit in the double negative, but he's answering, I believe that race was part of the reason.
Right, but a response in a deposition is not the same as raising a formal claim. And so, here's where I'm running into trouble. The hearing officer waives the certification conference, which, based on my reading of the regulation, seems to have been mandatory. But even if that would be cured by having a pre-hearing conference, which is what he or she did, it seems like the regulation mandates that the commission issue a certification of the issues to be decided at the hearing, and that was never done here.
So what I would say to that, Your Honor, is that it is common at the MCAD to waive the certification conference. Pursuant to 804 CMR 1.01, the commission may, in the interest of justice, relax the application of the regulations. And that was what was done here, and that is what has been done in many cases, and opens up to the parties the opportunity to identify the issues before the commission. That's what happened. At the certification level, respondents themselves identified this issue specifically as the issue.
You're talking about in the pre-hearing memo?
Yes. So the certification.
I don't really understand why. Well, I understand why, but I don't see why we should focus on what the respondent said as opposed to what the claimant said. And when I read the claimant's part of the pre-hearing memo, nowhere did it say that he was raising this claim. And I read the respondent's portion of the pre-hearing memo to be saying, it appears that they might be raising this claim, but you, Commission, should not certify it as an issue at the public hearing. Now, I don't see how that means he's on notice of the claim. And so what I would have thought would have happened is that the hearing officer would take that pre-hearing memo and then issue a certification of the issue so that we can avoid any confusion, which obviously still existed at the time of the hearing. So does the Commission routinely waive the requirement that there has to be a certification of the issues? Because, you know, as you say in your brief, that's the equivalent of the complaint, the formal complaint.
That's correct, it is. What the Commission does is it incorporates the issues identified by the parties, and that is explicit at RA 113, where the Commission said that the parties would be given a full opportunity to address the issues in dispute. And I should note that the pre-hearing memo was a joint pre-hearing memo, and in it, this specific issue was identified. And if I may, there were other times in the proceeding that respondents made very clear that they were on notice of this issue. At the public hearing, there are numerous attempts by respondents' counsel to narrow liability around the issue of whether or not this was a racial termination. And I specifically refer to RA 2 199 and RA 2 226 through 227. You can see him trying to limit the decision-making to Mr. Romano and not others. So
I'm sorry, you can see
the questions that are designed to, that identify that there may have been one person who engaged in discrimination in the termination of Mr. Sims, but it might not have been others. So again, the transcript reflects an awareness of this claim. And even after the hearing, the club states Romano did not treat African Americans differently from others because of race.
There was clearly a claim of hostile work environment based on race that was raised. So it is hardly surprising that the respondents' counsel would be asking these kinds of questions.
Well, some of the questions relate specifically to the termination, and that's
Could you point me to that, because I did not see that in the transcript.
The sites that I have are, I'll give you an example. There were questions around the termination, such as, respondents' counsel specifically asks, did you ever fire bouncers for supposedly not showing up to their post at other bouncers? And the question elicits a response around whether or not there were non-white, whether or not there were
what page
white
are you on?
bouncers.
What page are you on? I'm sorry.
That's RA 298.
298.
298. So there, the owner of the club is unable to identify any white bouncers who were terminated for similar circumstances. So that's an example of the question relating to the termination and to race.
Wait, isn't this examination by the claimant's attorney?
Yes.
So how does that show that the respondent is on notice?
Well, if he's hearing, I believe that's respondent's counsel's question at 298.
No, I don't think so.
Okay, so, well, then I would say that is classic evidence of pretext. There is.
And the pretext is an issue in the retaliation claim as well, right? I mean, the claims that were brought have intertwined issues with the claim of termination based on race had it been raised. So it's really hard to take what happened at the hearing and the examination of the witnesses and say that that means that they were on notice of this claim that has overlapping issues.
Well, Your Honor, yes, of course, the hostile work environment has overlapping issues with the termination.
And so does retaliation, right? I mean,
so does retaliation. You're correct. I mean, I think that there are aspects of pretext that were shown around the retaliation that relate to the termination. But I don't think it's fair to say that respondents' counsel had no awareness of this claim. First of all, it's throughout the process, it's clear that that's one of the claims. And when he himself identifies it at the joint pre-hearing conference, and there's discussion about it at the beginning, where counsel for Mr. Sims says race played some role in the decision to terminate.
But as your brother pointed out, there is a paragraph that is omitted from your brief, or I believe it was omitted, where Mr. Sims' counsel clearly says the two claims are hostile work environment leading up to termination, up to the point of termination, and then termination based on retaliation. That seems to be quite clear to me that there are two claims: hostile work environment based on race and termination based on retaliation.
Well, Your Honor, we respectfully disagree. We believe that they were on notice throughout the process, and particularly in a case where racial epithets are being thrown around by the decision maker, where there's evidence of, this was a serious and reliable and diligent employee who is African American, who is terminated, and who is terminated under circumstances that deviate from past practice. In this case, there was evidence that the respondent would let errors go. So for other bouncers who made a mistake early on in their employment, they'd pass it over. But in this case, we have an African American employee who is a serious and reliable employee who has never been warned for being late or any other attendance issues, who's never engaged in some of the things that my brother referenced in the position statement, all of which, or several of which, were found to be false. And then a deviation from past practice. We have bouncers who make similar mistakes who are not let go. And then a question.
But we don't have to question any of that with respect to trying to determine the issue as to whether or not this claim was specifically made, right? In other words, there's no, I'm going to say hypothetically, because of course we haven't decided the case yet, but there's no reason for us to doubt what a serious and dedicated employee Mr. Sims was. And that would not preclude us from also determining that there was no notice on this one specific basis for the termination claim.
Well, I would say there was notice in part because of all the evidence that supported the pretextual termination. There was, as I said, there was the falsity of the reason provided. There was deviation from past practice. There was an unrebutted testimony by the dancers that there was a racial term where they would not allow more than 2 Black dancers in the evening, and they wouldn't allow them to dance one after another. There was testimony around, so there's all this testimony about different terms and conditions. Different terms and conditions applied to Mr. Sims, different terms and conditions applied to other employees. And here we have someone who is terminated. I agree, he seems to have thought that it was for a different reason, but given all the evidence that came in showing that this was pretextual, on top of the fact that there were racial terms being thrown around in the workplace.
If I understand your position, there is the rule that we accept the case as the case was tried and presented. Is that what you're really relying on, in the sense that this was an issue, and even though the person who was whose employment was terminated here, Mr. Sims, might have thought it was X, given his testimony and given the evidence, the hearing officer could still say, well, it was really not just X, it was X plus something else.
Yes,
and that's fair.
Yes, I would say that, but I think that
It was not X, but it was Y.
I'm sorry, Your Honor?
I said, or even that it was not X, but it was Y.
Yes. Yes, and I think that, a fact finder needs to be given a certain amount of discretion to follow the evidence that's before her. If somebody comes in with a sex discrimination case and utters a racial epithet in the course of their testimony, we wouldn't want the fact finder to ignore that. And
No, of course not. Of course not. But I guess one of the things we have to decide is what's the appropriate step? Is the appropriate step to say time out? I want more discovery. I want the complaint to be amended, or blah, 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 or just to go ahead and incorporate that and address another claim. That's the issue. It's really procedural more than anything else, right?
Well, yes, Your Honor. I mean, our position is that it was laid out through incorporation of the joint hearing memo. But yes, if you reject that argument, I would say that the evidence is so replete in the record around the really critical elements of showing race discrimination, race termination. And even though there is overlap with retaliation, as Justice Shin pointed out, that doesn't mean that it shouldn't have put Respondents' Counsel on notice of the issue. And the requirement is that they be reasonably on notice. And under Langlitz, which is cited in our brief, Langlitz versus Board of Chiropractors, that the claim does not need to be pleaded with criminal specificity. And I would argue that the incorporation of the joint pre-hearing memo is that reasonable notice.
Okay. I'm gonna, I gave you just a couple seconds more to finish your point like I did with Attorney Merrill. So, but before I let you go, I'm just gonna see if the panel has any follow-up questions.
I have one question, Justice.
Please go ahead.
It's on the emotional distress damages. The hearing officer cited the Stonehill factors, which include, the length of time that he suffered or expected to suffer, whether he attempted to mitigate his damages. So she cites them, but I don't see where she applied them. And, Stonehill does say, as you point out, that expert testimony isn't required, physical manifestation of symptoms isn't required. But then it also goes on to say that a victim of discrimination isn't automatically entitled to emotional distress damages. So if you take the testimony of a discrimination victim that they were, very upset by this conduct as supporting the award, why doesn't that equate to an automatic entitlement? Right, because isn't it going to be the case in, I would venture in most, if not all, discrimination cases that the victim of the discrimination is going to be able to get on the stand and testify to some of the, the upset that they felt from it? So why doesn't that equate to an automatic entitlement? How do the Stonehill factors get applied at the MCAD level?
Well, she cited to testimony in the record that he felt that he couldn't believe that he had to endure racism in the 21st century. And the record shows him referring to all sorts of feelings around the hostile work environment, feeling that he had to be ashamed to be who he was when he was with Romano, describing being a dog, being a rag doll, feeling disgusted and worthless, all of which are cited in my brief. So I would say that that's not an automatic assumption of the Stonehill factors. I think that's incorporating the testimony by the complainant that he suffered, that it lasted some time, and that it affected his everyday life, both from the hostile work environment claim and also just the incredulity that he had been terminated so suddenly when he was always a serious, diligent, and reliable employee.
Okay.
If there are no further questions, I will rest on my brief.
No, I see none, and thank you very much. Thank you both very much for your argument, and we appreciate it, and we'll take the case under advisement. And second, if we have any technical difficulties, just be patient. They're generally resolved quite quickly, and no one will lose any time. I apologize. Apparently, I have some sunshine coming in on my. I hope that's not distracting. I can't seem to find a way to get away from it at the moment, so we'll just have to leave it as it is. I'm going to now call the case 2019-1820, and it's Michael Lopes-RAFERTY versus Pedro Aguilar-Santos. And Attorney Shapiro, you represent the appellant, so you may begin.
Thank you very much, Your Honor. May it please this honorable panel. I'm Jordan Shapiro, and I was not the trial counsel in this case. I'm handling the appeal for my client, Michael Raftery, who was a healthy 26-year-old on July 11, 2016, who was working as an electrical apprentice and going to school nights. And now he's a paraplegic, confined to a wheelchair for the rest of his life. He's actually with me today, and you can hopefully see him in any event. So he was struck by Mr. Aguilar, who was negligently driving a truck that apparently was stolen from a friend. The summary judgment decision below seemed to focus only on the issue of scope of employment. Aguilar was a laborer driving to work, and that was the end of the case. Our biggest problem was that the judge below ignored the Holyoke affidavit, which is the RA page 164. And that's so even though the defendant said that affidavit was worthy of consideration by the judge. And the defendant argued at page 14 through 17 of his brief that the judge did consider the Holyoke affidavit, and they have no objection to the judge doing that. And still the judge came back finding summary judgment for the defendant, and note that in that decision, the word Holyoke never appears at all.
Well, our review is de novo in any event. So, I mean, we can consider the statement if we find it appropriate.
That's what I'm hoping you will do. And that's what I think was an error of the judge below. So we saw 5 issues of material fact in addition to that. And something that I discovered last night as I was preparing for the argument was at page 73, lines 14 through 20, the plaintiff's attorney then asked Aguilar why he parked where he parked. And Aguilar said, no one told him to park there. He just went there himself. But at page 153 of the appendix, Johnson, who was his boss, says he told Aguilar to park there a week ago. The depots of both Aguilar and Johnson look very, very consistent, except for this very important fact that he moved the car after being told by Johnson. We see that as essential. Issue of fact number 2.
If I can ask you, there is no question, is there, that Mr. Aguilar-Santos' job was to be a laborer, correct?
Absolutely correct.
And there was no, and he was not a driver, exactly. And he was not in a company car at the time that this happened, this terrible accident happened either, right?
That is correct. That is correct.
And then how is, even if we were to accept Mr. Holyoke's statement, for the truth of the matter, if we were to accept it, what difference does it make with respect to those facts?
Well, the difference is that if Aguilar was following an order of Johnson to move his truck, then he was doing something as commanded by the boss. And so the line of cases, actually a few cases, the Tennessee case that I cited in my reply brief, Kinad, the Clark case that I cited in my reply brief, Clark, and actually a line of Massachusetts cases.
Okay, but just so before we review those cases, just so I'm clear then you agree, if I understand correctly, that he was not doing anything with respect to his job responsibilities.
I disagree. No, I don't agree with that. No, actually, if you see what Holyoke says, he said they both arrived at work at 6 a.m.-ish, around 6 a.m. And that you will see that Holyoke's affidavit says that he was already out of his truck and he had to get back into his truck in order to move the truck.
Would that fall under your argument that he was commanded to do something by his direct supervisor?
Exactly. That is
okay. So I understand that argument. I'm just trying to understand if you are still arguing, which is why I understood you had to have argued in your brief as to whether or not when Mr. Aguilar-Santos went to park, he was doing anything in the course of his duties and responsibilities of his employment. And the answer to that would be no, because he is a laborer and driving the truck would have nothing to do with that. The theory that you're relying on is that he was commanded to do this, or there was there's a dispute of material fact as to whether he was commanded to do that or not. Is that right?
That is, you follow exactly what my issues are. Correct.
And he hadn't started work that day yet, right? Because his helmet and his vest and whatever is still in the truck.
Well, that
Right.
we don't agree with. That's an undisputed fact either, Your Honor, and that's because he, according to Johnson, Johnson says Pedro got into the truck and drove out of the lot and headed towards the parking lot, which to me, again, we don't have all the details, but it implies to me that he had arrived at work 5 or 10 minutes before that. He said he was running a little bit late and he was only 8 minutes away from the job site. And so he arrived a few minutes before that, and he was already starting to he was already on the payroll, on the clock for his employer. He was already doing whatever he was doing to prepare for the employer's work, and he was at the site working. That was paid for that period of time to work.
You don't, the fact that his helmet and his vest or whatever were still in the truck, to you, that doesn't detract from the notion that he was already on the job?
Could cut either way. Yes, Your Honor, I agree with that. What you just said, yes, that's true. I say that doesn't necessarily lead you to conclude that he had not started to work, because Holyoke says they get to work, they start getting ready for work outside of the truck, and they didn't need to put the helmet on until they started to need to put the helmet on, which apparently hadn't begun yet. So they didn't put the helmet on yet. So another issue of fact that we think is important, that Holyoke again says he heard Johnson tell Aguilar to move his truck, and apparently the defendant says that they deny that. So that's a fact issue certainly for the jury. Another issue that the judge wrote in his decision was that the Aguilar was parking where, quoting the judge's statement, parking where apparently he was instructed to park. So there's the question of the judge's mind, even in the judge's mind. Is this an issue of fact, whether he was instructed to park there or not? That's in the judge's decision, second paragraph. Another part of the judge's decision, there was a concern. He concluded at the end of his decision, there were other fact issues, quote, that the judge said were not material. I would respectively suggest that he should have told us what they were, especially since the Holyoke affidavits is not referred to anywhere in the decision. The name Holyoke has not appeared anywhere in the decision. He should have said, I'm considering the Holyoke affidavit. I'm not considering it. We have no idea how he treated the Holyoke affidavit. And we say that is an error. And the fifth complaint that we had, again, is the difference between arriving at 6 a.m. and 7 a.m. And we say, why would Aguilar say he was worried about arriving late if he didn't even have to show up until 7 a.m., which is what Johnson says? It's undeniable that he was there at least 6:20 to run my client over. And so Holyoke says in his affidavit that Aguilar was out of the truck and working and got into the truck to move it. More likely that he didn't show up 40 minutes early on a day that he says in his deposition, I was really scared I was going to be late for work. Obviously, the work time begins at 6 a.m. and that's why he was paid to work from 6 a.m. My brother also complained, and I don't see the clock. Oh, now I see the clock. Okay. Now, my brother also complained that that Holyoke is unlikely to show up. Judge didn't make any findings about that, but my brother said that it's unlikely he's going to show up. Well, Your Honors don't know, but we got Holyoke's affidavit in June of 2018 when he wanted to be honorable and helpful to my client before apparently he had spoken to his employer. And then all of a sudden, when we go to do the deposition, he's not showing up. And so if my client has a trial, which I hope to grant him, I will definitely get Mr. Holyoke into court. I know how to get bench warrants. I've done those before. There's no reason for the judge to have accepted the defendant's argument that he won't testify if that's what the judge concluded and why he excluded Holyoke. So we conclude that if Aguilar was following the command of Johnson to move his car, which we say was to benefit the employer, then we say respondeat superior applies. Let the master answer is what respondeat superior means. And so we say he was just following the orders of the boss and the employer must be liable. We cite some cases that say master-servant relationship is normally a question of fact. That's at page 12 of my brief. I do urge the court to read carefully my reply brief with the case that talks about quote, special mission, that theory, that's from the Kennard case of Tennessee, that is almost the same exact facts as our case where the fellow was told to move his car out of the way so a truck could be where he parked. And they found in favor of my client again with the control of the boss. Clark case also of New York, Clark's in control. And again, we have a series of Massachusetts cases, Connick versus Burke and Gonzalez versus Fern, that also talk about control, not focusing on whether the employer was or was not actually working, but he was told to do something by the boss. I'm going to conclude a little bit early, I guess, and say that my client wrote to me the other day and said to me in his letter to me, the court system exists for two reasons, justice and truth. He says, I've been denied both. So my client prays that you will give him his day in court. We thank you very much for your attention. That's all.
Okay, thank you. Just before you sign off, I'm going to check to see if the panel has any follow-up questions for you.
Absolutely.
I don't see any. Okay, I see none. Thank you very much. And we'll hear now from Attorney Palmer.
Thank you, Your Honor. May it please the court. I'm Peter Palmer. I represent the defendant, appellee, CRL Inc. There are three reasons, Your Honors, why the lower court decision granting motion for summary judgment should be upheld. And they are that there were no genuine issues of material fact that were in dispute. All inferences were in fact drawn in favor of plaintiff. And most importantly, perhaps, plaintiff failed in what is plaintiff's burden of proof to show that Mr. Aguilar, a man who admits he had stolen another man's car, was acting within the scope of his employment while he was parking that car on the day of the accident. So starting first with the issues of material fact, I would suggest to this panel that the entire Holyoke statement, it is not an affidavit, it's a statement, is a red herring. I would suggest to this court, as Justice Shin said, you certainly sitting de novo have the right to do with it whatever you wish. But I would suggest that the only reading of the Henry decision where he references facts that were only contained in the Holyoke affidavit was he had it in the record, he considered it. Our position is he should not have considered it, but he clearly did. He should not have considered it because it meets none of the foundational requirements of an affidavit. This is a document that was produced at a deposition without any authentication. I have no idea where this statement of Holyoke came from. It is not attested to by a witness. It is not notarized. I have no idea if the signature that says David Holyoke comes from a David Holyoke who was employed by this company or someone other David Holyoke or someone signing that name falsely. He does not.
Were any of those issues raised at the summary judgment stage?
Yes, in our underlying brief, we said that it is not an affidavit. Now, we brought it up in our original motion because we knew plaintiff was going to rely on it, so we referenced it in anticipation. But it was not submitted as a separate affidavit or exhibit in the lower case. It was attached as an exhibit to Nathaniel Johnson's deposition transcript, which was submitted. But
is that where it was submitted as Exhibit 3? Was that to the deposition? Okay.
Exhibit 3 was the Johnson transcript. Exhibit 1 to the transcript, marked only for identification by plaintiff counsel, was this statement. So it is physically in the record, but it was not. If you look at plaintiff's opposition to the motion for summary judgment, plaintiff does not rely upon it as an exhibit in their opposition brief. It's in the joint appendix of exhibits, but it's there as a marked for identification exhibit only in the Johnson deposition. So, but it doesn't speak to his competency. So we have no idea who actually signed that document. We have no idea if that person is competent. And we don't know that certain things in there were made based upon personal knowledge. So I say it doesn't arise to the level of the affidavit, but assuming the court disagrees with me, the more important fact is that although it has some factual information, which would contradict the information that plaintiff is relying on. And keep in mind, plaintiff must have the testimony of Aguilar to support the case. Aguilar says in his sworn deposition testimony where he was identified and authenticated, I never went to the scene. I drove by the scene, made a U-turn and crashed the motorcycle. I never spoke to Nathaniel Johnson. I was never there that day. Plaintiff takes fact A from
You mean,
Aguilar.
you're talking about the location, you're talking about the work site when you say that.
Correct.
Right.
And Aguilar's sworn testimony is he never got there. Johnson's sworn testimony is he never got here. They're seeking to introduce a statement of this gentleman, Holyoke, who they had the opportunity to depose, and they had the obligation to secure for him an affidavit in proper form as part of their opposition to the motion of summary judgment. They can't just rely upon an affidavit or a statement that's not in proper form. Once I serve that motion, it's incumbent upon them to produce this witness. And as my brother said, they could have gotten a bench warrant. They noticed his deposition once, he didn't show up, they gave up on it. So they put all of their chips on this statement. They didn't bring him forth, and they didn't go get a proper affidavit from him to oppose the motion for summary judgment. But the most important thing about it is, although the Holyoke affidavit does bring up some facts that might be disputed between Johnson and Aguilar, those facts are not material to Judge Henry's decision because they go to two elements of respondeat superior that Judge Henry did not rely on. There are four elements, as we all know. The kind of work he was employed to do, labor. You've already touched on that, Judge Vuono. Second, timing. The Holyoke affidavit goes to timing, whether he was there at 6, whether he was there at 7. It goes to the fourth element, control. Does the employer, it's not the question, did the employer actually exercise control, but did the employer have a right to control? It speaks to that. But what it doesn't speak to is the two grounds that Judge Henry granted a summary judgment, that this was not the kind of work he was hired to do, and that this was not something that had as its motivation to serve the business purposes of CRL. The statement—
Arguably get the truck out of the way so they could dig up the gravel or dig up the concrete, right? Serves the business purposes of CRL, right?
It does not, Your Honor. I would liken it to if the employer were a football team and the employee drove his car out and parked it on the 50-yard line, and the employer said, please move the car so we can start the game. Moving that car doesn't benefit the employer at all. This gentleman, Mr. Aguilar, stole another man's vehicle. He says,
you keep saying that, and I'm sorry that I was, a criminal lawyer in a prior life, and you don't have intent to deprive permanently, number one, arguably, but number two, what difference does it make? If it was his truck, right, that was in the way, whether it was the U-turn and he hit the gentleman, or whether, it was just in the way, that doesn't make any difference here, does it?
It does not, Your Honor.
Okay.
But as to the significance, if you believe that he was asked to move it, the only place that comes from is the Holyoke statement. You'll see Mr. Aguilar says, and if you refer to the record exhibit 72 to 78 in page 93, did you stop in and tell the boss you were running late? No. Did you talk to anybody at the project before you had the accident? No. Where were you headed at the time you had the accident? To my job. I was getting to my job. From the time you left Mr. Carrera's house until the time of the accident, did you make any stops and get out of the truck? No. You didn't pull over at the project and roll down your window and yell out to anyone? No. That's the evidence that that's witness A they want to call, because to rest their whole case on that. Now they want to rely on this unverified statement of witness B to contradict all of that. So I don't think I'd be allowed to do that at trial. I don't think my brother would be allowed to do that at trial either. He's not trying to impeach him on something he's surprised on. He's trying to have it both ways. So when he parked, if you give credit to the Holyoke statement that he parked this vehicle there, also please give attention to what Holyoke says in that statement. When Pedro arrived at work, he had originally parked the truck he was driving in the parking lot that we were working in. Shortly before the accident, I was standing in the parking lot and preparing to begin work. Holyoke saying we hadn't started work yet. He doesn't say anywhere in this statement that Pedro had affirmatively started work of a kind that involves moving trucks or that was intended for the purpose of benefiting the employer. Then he says, I heard Nathan tell Pedro he had to move the truck. Nowhere in that statement does it say why he had to move the truck. This is not a special task example as in the Koenig case, where an employer has an employee who is a laborer who shovels asphalt, as this gentleman did, and then says, oh, by the way, I have another task that you don't usually do, run over and pick up payroll, as in the Koenig case. This only information we have from Holyoke is Nathan told Pedro to move his truck, not to do a task for the benefit of the employer, but to get it off the lot that he was supposed to be digging and shoveling, that he was not supposed to have parked in anyway, because Johnson had told him a week earlier, we don't park here, this is the lot we're excavating. So there was no benefit to the employer reminding his employee that you're not supposed to be parking here. It was the employee, if you give any weight to the Holyoke statement, which I asked you not to, is that the employee was obstructing the work of the employer and of the ultimate client, not doing his job. He had not gotten his vest, he had not gotten his hard hat, which he described as the only tools I need to do my job. My job's a laborer, my job is not a driver. So whether you credit Aguilar's statement that he never got there and he was driving to the Grossman's parking lot, which is entirely consistent with the Johnson deposition testimony, or you find credit in the Holyoke statement, the issues Holyoke talks about are not germane to the two grounds that the motion was granted on. They don't go to the kind of work and they don't go to the motivation to benefit the employer. So I just say that they're not relevant at all. They're not genuine issues of material fact. There are some disputed facts, but Massachusetts case law is there can be facts in dispute and still summary judgment be merited if those facts are not material to the legal issue that Judge Henry decided. And he decided very narrowly in his decision and on alternative grounds. He found he was a construction laborer and not a driver. He was not driving a CRL vehicle and was not doing the work he was employed to perform. Plaintiff also argues that having the employees park across the street from the job site was motivated, at least in part, to serve the benefit of CRL. That argument stretches the reality of the action. He was simply trying to park his vehicle so he could begin work. Those are the only facts that a jury would hear. So on that, the record is clear that Judge Henry did take into consideration the Holyoke statement, which he shouldn't have, but even so, two of the elements of the respondent superior were not met, and that's plaintiff's burden of proof on both those issues. They can't come back now and say, we'd like another bite at the apple because we didn't do our job the first time.
Well, thank you very much. And I'm just gonna check with the panel to see if there's any follow-up questions from anyone. I see none. All right, well, I want to thank you both very much for your briefs and for your arguments. And I want to assure you both, I know we know, the entire panel knows that this case is important to both your clients. That's not lost upon us. And so we'll take the case very.
And we are back live and on the record.
Okay, thank you very much. Good afternoon and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel to you. My name is Ariane Vuono. I'm joined today by Justice Sidney Hanlon and by Justice Shin. I understand, Ms. Farrar, that you were going to be the only one speaking on behalf of all the pro se plaintiffs. I want to tell you that you have 15 minutes to present your argument and that there is no rebuttal in the appeals court. So once you're finished with your argument, Attorney Vogmirovitz will argue, and when he concludes his argument, the case will then be submitted for us under advisement, and we will make a decision. Okay.
Okay.
All right. The case I'm going to call now is case number 2020-0435, 10 Diamond Street, Worcester Realty Company versus Samantha Farrar and others. The only other thing I want to tell you quickly is that if by chance we have some technical difficulties, please be patient with us. They usually get resolved quite easily and no one will lose any of their time for their argument, okay? All right, so Ms. Farrar, your 15 minutes will begin now. Go ahead.
Okay. Thank you, Your Honors, for hearing us today, as this is a very important case because it involves our house, our home that we've all known our whole lives. In fact, this is the house that I was brought home to after being born. In 2007, the mortgage taken out by Beverly Farrah, my Nana, only included parcel 1. In fact, if you look back to 1973, when my great-grandparents purchased the property, the mortgage still only included parcel 1. When U.S. Bank foreclosed on our home, the notice of sale specifically stated, upon information and belief, the mortgage contains parcel 2. So this means that they sold the property at the foreclosure sale as a package sale. And as the Nemo Dat rule, a person legally cannot sell property or goods that doesn't belong to them, which they have attempted to do for 10 Diamond Street Worcester Realty Trust. The record still shows that my Nana still owns parcel 2. You can refer to that in the supplemental appendix, as well as in appendix 1, I believe. So we have been heard by many judges. Sorry, I'm kind of nervous.
That's okay. Take your time. That's fine. I understand you had a trial in the housing court, correct?
Yes, we had a bench trial in the housing court, which we were continually objected to. Every time we tried to speak, we were objected to, saying that we didn't have standing because we weren't on the mortgage or because we weren't on the title, and so we were never able to we were never able to get any arguments out. And as promised to us by Judge Salvidio, we were supposed to be able to cross-examine witnesses, and we weren't able to do that. Only my Nana her hearing was last.
She was the person who was the owner, right?
Yes.
Nana.
Yes.
Her name is Beverly. I don't mean any disrespect, but I just.
Yes. No. Sorry. I can call her by her name.
No. I'm only just being clear, but she was the owner, right?
Yes.
The person who got the mortgage in 2007, right?
Yes. She was passed down the mortgage in 2001 and purchased her siblings out in 2005. The foreclosed mortgage was 2007. So the first time that we've heard of 10 Diamond Street Worcester Realty Trust was on May 4th when they stormed the house. And by storming the house, I mean they had drills and crowbars breaking into the locked doors. We had no clue who they were, nothing. At the time, she was 70, I believe. She ran up the 3 flights of stairs, screaming, crying, telling us that someone was breaking into the house. At the time, she was home alone with her 3-year-old great-granddaughter. So we went.
Can I ask you, was there something else happened as a result of that? Like, was there a criminal proceeding or any other consequences, or anybody else decide anything about that? Just that piece of it.
We had a TRO. We obtained a TRO through the housing court, and that day that we were being heard for the TRO, they tried to serve us by constable as we were being called into the courtroom for our notice to quit. So again, that's the first time that we've really seen them. That was the first time they've seen all of us. And it was just, sorry.
Okay.
So when that happened, when they stormed the house, they had called code. And so code has been involved in our case since they've called. And so after they served us the notice to quit, code served them with the orders to make repairs. And that was when they served us with the summons and complaint. So from day one, we've brought up retaliation because under, I believe it's MGL 186-16, just because it seemed like everything that we did, they responded back with the court. And with that, it was the bank signed the deed to the trust in April. It was April 14th, 2018. Sorry. But the trust didn't come into existence until May 1st, May 1st, 2018. So that's, what is it?
So basically, if I understand it, what the housing court has said in its judgment is that those are arguments that that you can't bring because you don't have a relationship with 10 Diamond Street Worcester Realty. Is that how you understand it as well? I'm not saying that's right or wrong. I'm saying, is that how you understand what the housing court ruled?
That's what they wrote. Yes. I don't believe that that's true and what they ruled, because if you look at the Kelly, Johnson, and Bailey decision, you don't need to be on the title to argue possession. And that's what this case is. We're arguing possession.
Okay.
And going back to...
So Ms. Farrar, sorry to interrupt, but the foreclosure related defense that you're saying you have standing to raise is that the mortgage, the original mortgage, did not refer to parcel 2. Do I have that right?
Yes.
Okay. I do see though on that mortgage that it does seem like at least the copy we have in the record does not include the description of parcel 2. However, it does have a specific reference to the deed, and it identifies the book number and the page number. And it does seem like the deed does describe both parcels. So yes. How do you respond to that?
So what happened was my great-grandparents, when they purchased the property, they purchased both properties. They took a mortgage out on parcel 1 and bought the parcel 2 out in cash. So parcel 2 has never been mortgaged. And when they passed away, they passed on the property as a package to my grandmother. And she never put a mortgage on parcel 2. So that's how there's only that parcel 1 only has the mortgage on it.
So even though it refers to the deed, you're saying that the mortgage was still only on parcel 1?
Yes.
Okay, what's included in parcel 1 and what's included in parcel 2?
That still is unclear to me which parcels are which, because according to there's a few different realtor websites that say parcel 1 and parcel 2, where parcel 1 is the house, parcel 2 is the rest of the property, but then it's flipped sometimes too. And then there's the title examination letter that's in the supplemental appendix that states there's 3 parcels, and parcel 2 has 2 parcels on it, and that's backyard. So I'd be going with that, the title examiner description. But then with how the bank signed the deed over to a non-existing trust and containing the 2 parcels as a package, that goes under the statute of frauds, chapter 259, section 1, because the bank never legally owned parcel 2. So how could they sell it? In the court, we continued to argue the foreclosure. And like I said, we were arguing possession. So that goes with the Bailey decision and the Kelly Johnson decision. We don't need to be on the title to argue possession. And again, it's still Nemo DAT rule. You can't sell something that you don't own. So if the bank never owned parcel 2, they could never sell the package, or they could never sell the property as a package to the trust. So then the trust legally doesn't have a right to, or even standing to bring a case against us for eviction. Can't evict anyone from a property that you don't own. You don't. It's kind of like if I was to write up a deed to the Brooklyn Bridge and give it to you, Justice Renew. You wouldn't own the Brooklyn Bridge just because I gave you the deed, just because I said that I owned it. It all goes to with the statute of frauds. But But on our bench trial, we were trying to argue, well, we were so excited because it was 6 days after the Jardy case was argued in the SJC, where Standing and Hatcher were really brought up. And so we were excited to finally maybe be heard. And we weren't even allowed to be heard. Every time that we said something, we couldn't even get a word out, and the attorney objected. And Judge Salvidio allowed it.
So forgive me if you've answered this already, but so Beverly Farrar is on the mortgage, is that correct?
Yes. Okay. Yes. We also tried to file a memorandum that day, and both clerks denied us and the judge denied us filing it. So once the judgment came down in favor of 10 Diamond Street, we put in a Rule 60B4 motion against the voidness of the judgment. That was denied. We also put down a notice of appeal. That was denied.
But that was reinstated then, right? You come to the appeals court once before, and you were able to, and that's why you're here today.
Yes, because the panel referred it back down to housing court on bond. And when we went to court for bond, it was still in the remand period. She said that because we were indigent, we didn't qualify, or we couldn't do bond.
Right, and they give weren't a use and occupancy payments ordered at that point?
Yes, but because according to
$500 a month.
I couldn't hear you. Sorry.
I beg your pardon. 500. My understanding was that there were several different orders, but this one was $500 a month.
Yes. But because according to the indigency court cost law, if you're indigent and you don't qualify, well, you can't get bond. You really don't have use and occupancy, and their right to use and occupancy was taken away on October 17th, I believe, where Judge Salvidio stated that because they didn't list it in their summons and complaint, they couldn't get it.
Okay, but wasn't she talking about pretrial use and occupancy? That was what was at issue at that hearing, right? Because that was in October of 2018, I believe. And then
I still haven't been able to get the hearing transcripts because they have it locked. And I've put in multiple requests.
Just based on the procedural history, the history of the case, that hearing took place about 2 months before trial, right? So I think, what's at issue then would be use and occupancy before there's a judgment that's issued. Is that your understanding?
No.
It's not?
No, I lost right now.
I'm sorry. So the hearing that you're referring to, did that occur before trial or after trial?
It occurred before trial.
Okay.
But I just want to really reiterate the fact that they knew about the code violations the day that they came onto the property. We also told them about our issues with the foreclosure and how we were fighting the foreclosure and how it was void. So they knew on May 4th that the foreclosure was void. They signed the mortgage on May 1st, so they had plenty of time to rescind that mortgage. It is the Bellavacqua decision that it's not up to us. It's up to if they bought the property, the third party purchasers bought the property when the foreclosure was void, it's up to the third part. There's nothing that they could buy really, but it's up to the third party to go after the bank then. And we told them how the foreclosure was void. So they had plenty of time to rescind their mortgage. And I am more than willing to put in an extra brief about that if you would like. Yeah, and you can, everything else is in my brief.
Okay. Yep, we have your brief and we've had a chance to review it. I'm just going to see if anyone else on the panel has another question. I see that Justice Hanlon does.
Does your grandmother, your name is Farrar, am I saying it correctly? Yeah. Does your grandmother pay the taxes and the insurance, or does the trust pay the taxes and the insurance now?
I am not sure. I all I know is that she was getting checks from Wells Fargo regarding the foreclosure situation that happened in 2008 or 2010, I believe, because she was part of that thing.
Okay. And as far as you know, does anybody pay any money at all to live there?
The first and second floor pay the use and occupancy to escrow, and because of the code violations, we stopped. But we went into court and we said that we could pay.
A couple of, maybe 2 months, right? I think that's right, and then stopped.
Yeah. But the first and second floor hasn't stopped. They're still paying. But because of the code violations, and when we went to court, we said that we could pay, and the judge denied that. The trust was willing to accept it, but the judge denied letting us pay the back pay.
Okay. All right. Any more follow-up questions from the panel? No. All right. Thank you very much for your argument. And now we're going to hear from attorney. I'm going to get this right. Vuono. No, I'm sorry. You're going to have to do it for me one more time, and I'll try and follow through.
You got it, Your Honor. It's Vuono.
Vuono. Okay. Good afternoon.
Good afternoon. May it please the court. My name is Tom Vuono, and I represent 10 Diamond Street, Worcester Realty Trust. I just wanted to answer a couple of the questions that came up at the outset. So my clients have been absorbing the carrying costs since they've acquired the property, which includes taxes, water and sewer, insurance, the like. They've received use and occupancy payments following the remand from this court back down to the housing court for determination of the appeal bond back in July of 2019. Ironically, Ms. Samantha FARRAR and Brian Beebe are the only ones who never filed a motion to waive the appeal bond. But nevertheless, Judge Horan concluded that because all these cases are interrelated, she nevertheless ordered the $500 a month payment. Because Ms. Samantha FARRAR and Brian Beebe, I believe, made one payment, I moved to dismiss their appeal on behalf of my clients. That order was allowed. And as part of my brief, I'm suggesting respectfully that their arguments or their briefs should not even be considered, and their appeal should be dismissed, and the order of dismissal should be upheld. I believe the other issue that came up, there was reference to a title exam. I had filed a motion to strike that. This is some title exam from late 2019. The trial was in December of 2018. And certainly if there's law in there that you are all certainly free to rely on, but to the extent there's any opinions or anything substantive from that title exam, I don't believe it's properly before you and should not be in the record. Your Honors, the trial occurred in December of 2018, I believe December 12th, and a judgment entered in favor of my clients on December 21st. Appeals were taken therefrom, but the judgments were based on findings of fact and rulings of law and certain orders, which included stipulations by the parties, including receiving a notice to quit in May 8th, I believe, 2018.
Well, I believe that the judge erred in that respect, because my reading of the trial transcripts is that at least two of the defendants did not stipulate that they received the notice to quit on that day. And it does seem like both on that issue and on the whether the defendants have standing to raise the foreclosure related defenses, the judge kind of swept everyone under the umbrella of the defendants and treated them as one person.
I acknowledge that there was some objections to the stipulations, and at that point the judge heard evidence, and based on the evidence that was presented, namely the deed to the property, the trustee's certificate, and the deed referencing the declaration of trust, the judge concluded that the plaintiff made out a prima facie case for possession.
The judge's findings say specifically that the defendant stipulated to that issue, which is error. Right? I mean, the judge didn't go on to then make findings based on the evidence that was presented. The finding is all the defendants stipulated to receipt of the notice to quit on May 8th, 2018. That's on paragraph 3, record 137.
Right.
Would you agree that's not accurate?
I agree that there was, I think some of the appellants disputed or refused to enter into stipulations. Okay. I do believe that. But nevertheless, I don't believe that there was any evidence presented of not having received notice to quit.
Right. I mean, they admitted that they eventually did receive the notice to quit. That was the evidence that was the hearing. But can I ask you about the foreclosure related defenses? Yes. Again, the judge said, as the defendants are not the mortgagor, they have no standing to raise foreclosure-related defenses and counterclaims. And that's erroneous too, is it not? Because Beverly FARRAR is in fact the mortgagor.
I agree, and I addressed that in my brief, Your Honor. Beverly FARRAR was the only one with standing to raise issues of title. However, these issues were raised. These issues were raised in a case that's in appellant's appendix, beginning in page 227. I filed a motion to supplement that because there was a missing page of that order. So
but I didn't see your client to have raised any argument based on res judicata or anything like that. And the judge didn't make any findings on it. She just said that nobody has standing, which is wrong. So what do we do with that?
Well, I argue that there's just doesn't seem to be any justification that to accept just the conclusory statements that the foreclosure was illegal or illegitimate. There was no evidence presented supporting this argument.
Well, most of these defendants were not allowed to present evidence because the judge said they didn't have standing. But how do you reconcile the judge's ruling with our decision in Johnson from, I believe it was last year, where we said that a tenant in possession does have standing to raise foreclosure-related defenses?
There's not, well, even if they had presented the opportunity to raise any such defenses, there's nothing in the appendix, there's nothing in the record that supports any issue with the foreclosure. The only...
correct me if I'm wrong, but when they tried to raise these arguments, there was an objection based on lack of standing, and the judge, I read the transcript as the judge precluding them from raising any of these arguments based on lack of standing, which Johnson seems to say is not right.
But they could have presented documentary evidence supporting why it is an offer of proof, or they could have put something in the record to support why the foreclosure was invalid and why the plaintiffs lacked standing.
Were they invited to do so at trial? Was there a point in time when anyone turned to them and said, could you supply the documentation or make an offer of proof?
No, I don't think that there was an invitation for them, but they were there. They've certainly filed a litany of motions, and they've presented all sorts of issues pre-trial and post-trial. So I find it hard to believe that if they had these documents with them, or specifically if Beverly FARRAR had these documents with her, she wouldn't have at least just tried or attempted to introduce that into evidence. If they had a list of
excluded it, right? And said, no, that's right. Nobody has standing, so you can't do it, right?
But there's no indication in the record that they were ready to do that. They didn't have all that was in the record was Beverly's testimony that this foreclosure was illegitimate and illegal without any backup support for it. And the case was decided when the bank was moving for summary judgment against the counterclaims, which is the identical ones presented here. and that there was no evidence to support. The only thing that comes close is, as Justice Shin was questioning the issue with the parcel, as best as I can see, there was this issue that because the one of the parcels was not referenced in the mortgage, but the deed specifically has the date and the book and page the mortgage specifically has the reference to the deed's book and page reference and the date to support that. And I don't believe this.
Do you agree that following our decision in Johnson, that all of the defendants in this case did have standing to raise the foreclosure related defenses?
I'm not certain. If you do conclude that they did, I suggest that there's nothing in the record to show that there was any valid defenses.
Well, I mean, this issue they raised about the parcels, shouldn't that have been resolved by the judge if the defendants had standing? I mean, I know you're arguing that because the mortgage contains a specific reference to the deed that the argument has no merit, but that seems to me to raise factual issues that the judge should have resolved.
But I believe it was raised. I believe part of the arguments there in the efforts to bring up standing, I believe there was references made to issues with the foreclosure and the mortgage, and right, they just had nothing to support that.
But the judge didn't resolve them. That's the problem I'm having.
And I would suggest respectfully from my client's perspective that had there been something presented, it would have been resolved, and the judge took the matter under advisement. She didn't make a ruling right then and there. If there was something that the appellants came to court with to present, then other than just a cursory allegation of a generalized argument that the foreclosure was illegal, then the judge could have examined it. But there was nothing because there is nothing, and this issue has been attempted to be litigated 2 months before by the same judge, and again during the trial, again post-trial in many different ways. Your Honor, I'm not sure if you want me to go on to all the other issues raised, these interlocutory issues, but I would contend that these interlocutory issues should have been challenged for under 231-118. But notably, the issue with the appeal bond and Miss Samantha Farrar's and Brian Beebe's failure to comply with that prevents at least their arguments from being appealed, or their judgments from being appealed. Mr. Beebe, and I provided in my appendix, Mr. Beebe did file for bankruptcy. That case, for some reason, has not been closed yet, so I have not filed a motion to dismiss his appeal and their appeal for not wanting to violate the automatic stay since the case is still open, but also because the other occupants of the property still remain, and the issues resolving their appeal would, I believe, resolve the other appeal too. And I'm not sure if Your Honors have any other questions, but I don't have anything else, and rely on my brief for the remainder of my arguments.
All right, just one moment. I'll check with the panel to see if they have any follow-up questions, and I'm seeing by their indication they don't have any. So I want to thank both of you for your arguments. They were very helpful. We know it's a serious case for both people. I know you've been up to the appeals court once before, and we'll take the case under advisement and get back to you as soon as we possibly can. Okay.